Thank you, Alec. Good morning, everyone. Welcome to the September 10th Board of Zoning Adjustment. I'd first like to thank city staff who have prepared cases on your behalf today. They worked very hard on that. And also, I'd like to thank my fellow board members who volunteer their time twice a month to come down and listen to your cases and make judgments about them. So thank you to all those. Before we start, Sarah, will you confirm everyone's in attendance and the court reporter is here too?
Court reporter is here, yes.
Good, thank you.
And we're ready.
Okay. I'd like to swear in all staff members who, actually, you need to go about the rules.
Yeah.
Thank you.
You ready?
Yeah, I'm ready.
Okay. I'll describe the procedures for today's hybrid meeting. First, for everyone joining us online, there are two categories of people participating in the meeting: attendees and panelists. Right now, the only panelists are board members and city staff. If you are an applicant or a member of the public who is interested in a case, please use the raise hand function when the case is announced to let staff know that you would like to speak. There is a ribbon at the bottom of your Zoom screen with a hand icon. Please click this to raise your hand to request a promotion to panelist. You will need to accept the promotion in order to speak. It may appear temporarily as if you have been disconnected, but don't panic. You will reconnect shortly. If you are joining us via the Zoom app on a smartphone or computer, please change your screen name to reflect your legal name. If you are calling in on a phone line, you cannot adjust your screen name. It appears as your phone number. You can still provide testimony by raising your hand when the case is called by pressing star followed by the number 9. At the time of promotion, you must turn on your camera and microphone to be sworn in. Your microphone needs to always be on mute unless you're giving testimony at the appropriate time. The chat box is only for questions about the agenda. Merits of each case are not to be discussed in the chat box. For everyone joining us today in person, please approach the microphone on the podium when it is appropriate to give testimony. Applicants may be seated at the center desk when the case is announced. Everyone planning to testify must sign in on the sign-in sheet that's near the door. If you are in person, there is no need for you to be on the Zoom meeting as well. Joining the meeting in both manners causes a lot of unnecessary feedback and audio disruptions. All public testimony, in person and virtual, is subject to the following rules. The BZA secretary or their designated representative will identify you when it is time for you to speak. You must be sworn in under oath to provide testimony. Please provide your full name and address when you are sworn in. Everyone, board members, city staff, and members of the public, need to speak closely and clearly into the microphone. The BZA has set time limits for all testimony during its meeting. These time limits are 15 minutes for staff presentations, 20 minutes for presentations by applicants, 2 minutes for testimony by individuals, and 5 minutes for testimony by persons representing an organization such as a neighborhood association, HOA, CID, or business association. You will hear an alarm when your allotted time is over. Please be respectful and wrap up your statement once you hear the alarm. We ask that there be no repetitive or irrelevant testimony. If you wish to admit exhibits, you need to have your exhibits ready on a jump drive or ready to share on your screen, and email the exhibits if they are admitted to the assigned planner. The Board of Zoning Adjustment may take breaks during the day. These are typically taken around 10:30 a.m., 12:30 p.m., and 3 p.m. and will be announced by the chair. Those are all of our procedures for today.
Thank you so much. Before we start to review cases, I'd like to swear in all city staff who are going to be presenting today. Please be sure your cameras and microphones are on. And you solemnly swear or affirm to tell the truth and nothing but the truth in this meeting today. If so, please state your name.
Sarah Copeland, I do.
James Duddy, I do.
Alec Gustafson, I do.
Anna Naniski, I do.
Connor Tomlin, I do.
Stephanie Saldari, I do.
Justin.
Justin Smith, I do.
Is that everybody?
Larissa Chomby has a case. We'll swear her in when she comes down for it.
That'll be great. Thank you. Sarah, I'm going to turn it over to you to identify continuances and or dismissals.
The first continuance is docket item number 4, case CD BZA 2025-107, a request to appeal a notice of violation related to window signage coverage on about 0.2 acres generally located at 300 East 12th Street. We request this case be continued to September 24th. And docket item number 11 is case CD BZA 2025-103, a request to appeal a notice of violation related to an outdoor vehicle sales use on about 1.4 acres generally located at 7730 North Oak Traffic Way. We request this case be continued to October 22nd.
Thank you. Do we have any testimony or comments on these continuances?
There are no hands raised online.
Great, thank you. Board members, I'll entertain a motion to those effects.
I move that we continue both dockets to the dates recommended by staff.
Perfect. I have a motion by Ms. Otto. Do I have a second?
Second.
Second from Ms. Mixdorf.
Gorens,
Aye.
Mixdorf,
Aye.
Otto,
Aye.
Wright,
Aye.
Ebbets.
Aye. Those matters are acted upon. And sir, I'm turning over to you to call the first case.
And we do have Jazz here now too.
Hey, Jazz.
Okay, docket item number 1 is case CD BZA 2025-100, a request to approve a variance to the maximum size of a monument sign plus any additional variances on about 1.3 acres generally located at 1001 Locust Street. Connor Tomlin is the staff planner for this case. We have an established quorum because it was continued from August 13th of Ebbets, Gorens, Hayes, Meyer, and Mixdorf.
Perfect. Good morning.
Morning.
Gonna take me a second here. It'll just be a second. There we go. Raise your right hands to be sworn in. Do you solemnly swear or affirm to tell the truth and nothing but the truth in this meeting today? If so, please state your name and the I do for the court reporter.
Austin Panko, I do.
Thank you.
Lee Moore, I do.
Great. There are a list of administrative exhibits associated with your case labeled 1 to 9. Do we have your approval or do you have any questions on those exhibits?
I do not.
Okay, and you okay to admit those?
Yes.
Thank you. Those are admitted. Part of that is a presentation by Connor. Connor, please tell us about this case again.
Okay, we have docket item number 1, CD BZA 2025-100, located at 1001 Locust Street at the J.E. Dunn Building around the corner. The zoning district is UR, and the request is a variance to the maximum size of a height of a monument sign, plus any additional variances. This is the general location of the site. With a closer look here, I included a tighter image there to show specifically where this monument sign is on the property. This is the original submission that you heard last time at just under 51 square feet. This is the revised submission at 36 square feet, roughly a 14, just shy of 15 square foot reduction in size. It was also noted that they are going to be moving it forward in the flower bed. This is from the previous hearing where I had showed an image that you can't really see it due to the structure of the building as well as the foliage there on the street. And then this mock rendering shows that they'd be moving it forward in the flower bed where it would be more visible from the street. And then this is a map showing that they would still meet that 10-foot setback requirement from the property line. With all of that being said, the variance is 6 square feet to the maximum area of a monument sign to permit this monument sign at a total area of 36 square feet. That is a 20% change. Again, that is down to 6 square feet from the original 14.75 square feet. A substantial change to the character of the neighborhood is anticipated. A monument sign currently exists on the subject site at a size that is sufficient for wayfinding and advertising. And the difficulty could be obviated through further change of design, such as reducing it to 30 square feet, which would be the compliant size. Variance request B is a variance of 1 feet 11 inches to the height of the monument sign to allow that monument sign to exist at 7 feet 11 inches. Again, that's a variance of 1 feet 11 inches. A substantial change to the character of the neighborhood is anticipated as monument signs in this area appear to be generally compliant with the requirements, and a monument sign standing at 7 feet 11 inches could appear quite large compared to existing signage along 10th Street within the immediate area. and the difficulty could be obviated, such as altering the design to have that signage at a height of 6 feet from grade. That concludes my presentation, and I'm open to any questions.
Thank you, Connor. Board members, do you have any questions of Connor? I like the reduction. Gentlemen, tell us why we should approve this new request, sir.
Yeah, so essentially we listened to everybody's feedback the last time about looking at alternative options. We reviewed that in-house with our leadership and ultimately came to significantly reducing the sign and also shifting it to the north, obviously far enough back off that setback to allow visibility from the street. This sign size also allows us to input our corporate logo that we currently do not have as well.
I, for one, appreciate J.E. Dunn's commitment to Kansas City and, of course, the reduction in size for this sign. So
I second that.
board members, any other questions, at least on the quorum?
What is the overall height of the actual text now? I see it's, 31 inches, kind of where the logo is, but do we have like
So if-
12 inches for where it says J.E. Dunn?
Pull in there. I don't have that. I'd say it's right around, 31 from the top of construction to the top of the rivet. I'd say 10 to 12 inches maybe.
Yeah, I appreciate that it's a less substantial variance. Moving it so that it's more visible makes sense.
Yep.
I'll make a motion.
Thank you, Mr. Hayes.
On case CD BZA 2025-100, docket item 1, I move that we grant the requested variances in accordance with site plan and staff report.
I have a motion. Do I have a second from someone?
Second.
Second from Mr. Meyer. Please call the roll. Thank you.
Gorence,
Aye.
Mixdorf,
Aye.
Hayes,
Aye.
Meyer,
Aye.
Ebbets.
Aye. Thank you very much for coming back before us with the new design.
Thank you, guys.
Thank you very much.
Thank you.
Thank you, Connor. You guys are
That's the only one.
Docket item number 2 is case CD BZA 2025-106, a request to approve a variance to the infill residential standards to allow a driveway access off the street where an alley is present in an R6 zoning district on about 0.07 acres, generally located at 2021 Mercer Street. Alec Gustafson is the staff planner for this case. If you are the applicant, you may be seated at the center desk. If you would like to testify in this case, if you would please approach the microphone on the podium to be sworn in. Or raise your hand online.
Anything, Sarah?
We do not have any hands raised.
Good morning. I'm going to have you raise your right hands to be sworn in. Do you solemnly swear or affirm to tell the truth and nothing but the truth in this meeting today? If so, say I do, along with your name and address.
5 Madison Avenue, Suite 64108.
Thank you.
Can we ask her to speak into the microphone because I can't hear that?
Do it
Cheryl
again.
Hartel, 1675 Madison Avenue, Suite 200, Kansas City, Missouri, 64108.
And
Good morning, Nick Christopher, 1517 Westport Road, Suite 201, Kansas City, and I do.
great. Who's speaking on the case today? Okay, thank you, Nick. There are lists of administrative exhibits associated with your case. They are labeled 1 to 9. Do you have any questions on those exhibits, and do we have your permission to admit them?
No, please do.
Okay, thank you. Part of that is a presentation by Alec on your case. Alec, please tell us about it.
Okay, today we have CDBZA 2025-106. This is at 2021 Mercer Street in an R6 zoning district, and it's a request for a variance in an infill area to allow a driveway off the street where an alley is present. The site is generally located in the west side. And here's a larger view or a closer view of the satellite view. It's West 21st Street and Mercer Street with the alley, as you can see, defined by the parcel lines behind the property. These are just images of the house that did exist there. It was demolished in, I believe it was 2021. So currently there is actually no house there. But as you can see, there was a driveway off of the street. As far as infill code requires, though, when there's an alley, driveways off the street are not permitted. And considering that the house is not standing anymore and the driveway is not existing, it reverts back to what infill code requires. This is the existing driveway with the retaining wall, the pavement, and the utility. Here's just another view of the house. And then this is the beginning of Nick and Kala's site plans. They're meeting all the allowable house footprints. They're meeting all the requirements for actually building the house, putting the footprint on the structure, abiding by all setbacks. The only difference is the driveway, the placement of the driveway. There's their plot plan. And then these are some points that they pulled out on their presentation. There's a power line, they say, obstructing the alley and garage access from the alley. And then the electrical poles in the alley, retaining wall, seemingly obstructs the alley, and the alley is seemingly not accessible on the east end. However, you can still get into it on the west side, which is where this entrance is. This is their existing site plan with the garage and the access off of the street, off of Mercer Street, and not using the alley. And then these are some renderings that they provided. And this would be the garage off of the street, and you can see where it seems like the alley is not existing. But this is what they're requesting, and we'll move forward to the variance now. It's a complete deviation to the infill vehicular use standards to permit a driveway off of the street where an improved alley is present per the submitted site plan. I said that there's a substantial change to the character of the neighborhood. All homes in the context area, meaning on the same block face and within 200 feet, have their vehicular access off of the alley or don't have vehicular access and they just park on the street. This also conforms with the intent of the infill ordinance. Permitting this property to have a driveway off the street does not conform with infill regulations and changes the immediate context area. This would be one of the only houses in the area, and specifically in the context area, defined as all homes on the same block face and within 200 feet. None of those have driveways off the street. So this would change the context area. The difficulty could be avoided by a change in design. The applicant could still have their garage, however, the drive off the garage could be off of the alley if they just move it from facing west towards the street to facing north into the alley. However, they would need to reorient the driveway. That concludes my staff presentation. I can answer any questions that you may have.
Board members, any questions of Alec?
When we say alley access, does it have to be through access, or is it just any alley access is what is triggering this?
Just any alley access. If there's an alley existing is what I read in the code.
And I think we
Go ahead. I'm just saying, and there is an alley existent, so.
And I think we had a couple of cases, maybe a couple of months ago, talking about what constituted an improved alley. Can you remind me of what those requirements are?
It's not up to Public Works' definition of improved. So improved would meaning, I believe that it can be used. That doesn't mean it's perfectly paved. That doesn't mean it's well taken care of, but it is existing.
And then the maintenance of those improved alleys, is that then not cleared by Public Works or anything then either?
I'm not sure
Or
what
the
Public Works
question,
is.
not a
Yeah.
PA question, but
Mhm. That would be a Public Works question.
Any other questions of Alec?
Teresa, do you want to use your microphone?
One on the first one. Do we have any photographs that show the rest of the alley all the way down, since there's been some indication that it's not completely functioning?
I don't have any, no.
I mean, because existing, if that's our definition, existing, if it's blocked, that's what I kind of want to know.
The code reads for this section, improved shall mean paved with a hard surface or gravel. It does not reference whether there is more than one access point to the street.
Thank you.
Okay.
Satisfying my legal brain today, thanks.
All right, Nick, why should we approve your request today?
We really do believe that we're trying to do something compatible with the neighborhood, and we agree, while probably on the immediate block face, that there's not precedent for this. But if you look just to the west of us, it's occurring, and if you look just to the north of us, it's occurring. We also do believe that the alley is not improved to a standard that really allows us to, immediately begin on this project. To make it improved to a state where we could use it, we would need to discuss with the owner to the north the retaining wall condition, which prohibits us from really not having to create a substantial amount of driveway on the north side of our site just to allow a clearance of a car. So we, again, think that if we design it this way, we're actually going to be more compatible with the neighborhood than trying to work with the unimproved alley. Then there's the issue of the electric pole, which would be a kind of cost prohibitive issue for us to resolve. In fact, both from just a first order of cost, but also just understanding the time constraint as a cost. So, this is we think we're doing something that's very compatible with the neighborhood. We don't think it presents an adverse effect to the overall neighborhood. We think that, again, it works well. We see this as kind of an unnecessary hardship to try to use the alley, and we don't see a kind of health and safety thing with the way we're approaching it. In fact, opposite, we think between the electric pole and the existing wall, we could be creating a safety issue for the home that we're trying to design. And so I just end with, we think we're by the spirit and intent of really the West Side neighborhood and the infill standards. And that, concludes kind of why I think we're doing something that makes sense for the neighborhood. Thank you very much.
No, thank you, Nick. No, please, go ahead, Ms. Otto.
Any homes on that alley, Nick, that have garages that enter from the back? Or no?
No.
There's none.
No, there's not.
So do any of the other houses even have garages?
They don't.
All right, thank you.
Have you had any comments from the neighbors?
No.
Are those owner occupied homes near you or those rentals? Or do you know?
There's a mix, actually. Yeah. My daughter actually lives in that neighborhood. She lives across the street from this site.
Okay. We've had these cases before with the alley access, and sometimes you just can't use the alleys. So I understand that. Right.
I have a motion.
Speak.
Right.
Ms. Otto,
Yeah.
go ahead.
Docket number 2, case number, hold on, let me get the case number here.
106.
106.
Yep, sorry, 106. I move that the board grant the request as stated in the staff report and outlined in the site plan.
I have a motion. Do I have a second from someone?
Second.
Second from Mr. Gorence. Please call the roll.
Gorence,
Aye.
Mixdorf,
Aye.
Otto,
Aye.
Wright,
Aye.
Ebbets.
Aye. Your request is granted. Good luck with your project and your new home.
Thank you very much.
Sure.
Appreciate your time.
Docket item number 3. It's case CD BZA 2025-13, a request to appeal the denial of a certificate of legal nonconforming use for a short-term rental at the subject location on about 0.1 acres, generally located at 321 Southwest Boulevard. Anna Naniski is the staff planner for this case, and we have the applicant present. If anyone would like to speak on this case, please approach the microphone on the podium or raise your hand to be sworn in. Online, I'm going to promote Lucas Taylor to panelist. Is there anyone else who would like to speak on this case? Okay, we have the one.
Okay. Lucas, turn on your camera and microphone, please, so we can administer the oath.
Can you hear me now?
There you go. Perfect. We see you and hear you.
Thank you.
Please raise your right, and Ms. Duma, please raise your right hand to be sworn. Do you solemnly swear or affirm to tell the truth and nothing but the truth in this meeting today? If so, please say I do or I don't, along with your name and address.
I do. Megan Duma, 2526 Holmes Street, Kansas City, Missouri, 64108.
Right. And Lucas?
4049 Pennsylvania Avenue, or sorry, I do. 4049 Pennsylvania Avenue, Suite 203, Kansas City, Missouri, 64111.
Great. And Mr. Lucas, are you opposed or supporting this?
Supporting.
Okay, great. Thank you. We'll give you a chance to testify in a minute.
He is the applicant.
Well, he's the applicant. Okay, thank you. All right. There's a list of administrative exhibits associated with your case labeled 1 to 10. Do we have your permission to admit those? And do you have any questions?
Yes.
Thank you, Ms. Duma. Part of that is a presentation by Ms. Anna.
Okay. Thank you. On Ananiski Development Management Division, as previously mentioned, this is case CD BZA 2025-13. The applicant is seeking to appeal the denial of a certificate of legal non-conforming use. We'll probably call it CLNU for short for the rest of this presentation, and it is related to a short-term rental request. So the site is located in the Crossroads portion of Kansas City, Missouri. More specifically, it is along Southwest Boulevard near the intersection of Broadway Boulevard. You can see the subject site highlighted in yellow on my screen. And then this is a look of the building from Google Street View. So it's a mixed use type building where there is retail and commercial on the bottom floor, where the upper floors are where the subject matter is located. So on February 6th of 2025, the CLNU for a short-term rental was denied for the subject property per the Zoning and Development Code, more specifically 88-610-01, a property, and that is any lot, use, building, structure, or any type of other development feature with non-conforming rights is one which is lawfully established at the time that it was established, which means that it's in compliance with all regulations in effect at the time of their establishment and has been made non-conforming by virtue of some sort of, change, zoning regulation, overlay district, etc. So to talk about some timelines specifically related to this case, so before short-term rentals were a identified use in the Zoning and Development Code, we consider those to be not permitted because they weren't an identified use in the code. I'll get into a little bit more later, specifically where it states that in the code. In 2018 is when we first see short-term rentals being regulated in Kansas City, Missouri. So it's first regulated by the Zoning and Development Code. And in 2019, according to some of the paperwork that the applicant has provided, is when the property owner purchased the subject property. And then between 2019 and 2002 is when renovations occurred and were complete. Since that time, they have been advertising, for this short-term rental, despite the fact that there have not been a short-term permit acquired, and that stands today. And then in 2003 is when the short-term rental ordinance as it stood in Chapter 88, the Zoning and Development Code, was repealed and moved to Chapter 56 of the Code of Ordinances. 2004 is when the CLNU application was filed, and then there's lots of research that's involved in that when it was denied and then appealed in 2025. So now I went over a high level view of all of the timeline. Now I'm getting into the nitty gritty of each step. Let me move this Zoom bar. Okay, so as I previously mentioned before, short-term rentals existed in the code. It was identified use. We consider that to not be permitted. 881007B in the Zoning and Development Code says that land may not be used for any purpose other than one that is permitted in this subject zoning district. And this statement, or some sort of similarly worded statement, has existed in the Zoning and Development Code since 1923. So basically since the zoning code existed. And for planners, that basically means if it's not specified, it's not allowed, or we can categorize it with some sort of other like use. So in this case, is it a hotel? Is it a bed and breakfast? Is it something like that? That's how we would identify something unique that's not specifically identified in the Zoning and Development Code. As of right now, we do not have proof that a short-term rental or any other type of lodging use was in this building prior to 2018. And again, per the Zoning and Development Code, as it relates to non-conforming uses, the property has to be lawfully established, which means that it has to meet all zoning regulations at the time of their establishment to have those non-conforming rights when the law changes. So no legally established use, no legally non-conforming use. Okay, 2018. 2018 is when short-term rentals were introduced into the Zoning and Development Code, but short-term rentals were not allowed by right. There was some sort of zoning approval and or permit that all short-term rentals had to acquire, depending on the type of short-term rental it was and the zoning district that it was in. The subject site did not obtain a short-term rental permit. Again, a legal nonconforming use is one that was legally established at the time of its establishment and then made nonconforming because of a law change. In this case, no legally established use, no STR permit, no legally nonconforming use. 2019, when the property owner purchased the site, this is a lot of information reviewed from the applicant's submittal where they acquired the property. They did get it appraised in the under the desire to have this be a short-term rental. The appraisal talks about short-term rental rates and long-term rental rates, but an appraisal, does not secure zoning rights. And the property was completely, renovated. They talk about adding the residential units, per building code, which includes like new water lines, electrical, plumbing, HVAC. From a building code perspective, a rental unit for a mixed use, building, so making sure that it's like that commercial grade type of a structure. It can be for a long-term or a short-term rental, so the building permit review team is just looking at that type of structure underneath those guys, not necessarily that it has to be a short-term rental. So we do have to consider, like what is the difference between, because you're going to hear a lot about this substantial conversion conversation from the applicant, like what is the difference between when you're converting a building from a long-term rental or short-term rental, whether it's residential living, another type of lodging situation, etc. We have the point of 2022, where the renovations were complete and furnished in September of 2022. 2022. The applicant's materials also discuss that substantial conversion that I just mentioned, and how there was lots of investment, made at the property by the reliance of these STR regulations. But in September of 2022, short-term regulations were in effect. They could have obtained a short-term rental permit at that time. And again, they weren't allowed by right. They needed to obtain that STR permit, which we do not have record of. They did not obtain. So again, this reaffirms when I'm gonna keep going back to the legal non-conforming use thing. Non-conforming property is one that was legally established at the time of its establishment in compliance with all regulations in effect. That's been made non-conforming because of a law change. So if there's no legally established use, then there's no legally non-conforming use. 2023 to today, when they start advertising and listing the property, as you could still pull it up on Airbnb today. They address in their applicants' materials about how when they became aware of the ordinance change, they called the City Planning and Development Department and asked about about these regulations, that they spoke to someone who instructed them not to apply. And if they had, they would have been like automatically vested or something like that. That's not necessarily accurate. If they had applied, we would have considered their application. If it was deemed complete and accurate, then yes, possibly they could have received that SDR permit before the rules were, repealed from Chapter 88, but we don't know that for sure because we don't have that paperwork in front of us, and we don't have any record of this interaction between a staff person and the property owner. So the ordinance was repealed from Chapter 88 and moved to Chapter 56. That's regulated by the Neighborhoods Department. They did apply for STR permits underneath those new regulations and were denied. From my understanding of the regulations, it's because there's a legally established STR within 1,000 feet of the subject site. There's a little screenshot of Airbnb just to prove that it is still being advertised today without Chapter 88 permit or Chapter 56 permit. And there are other possibilities, for the property that's not an STR. A condo plat can be done on the property so they can sell the units, long-term rentals, group living, office, so there are other possibilities to retrieve revenue from this property. In the CLNU application, this is a snapshot of that, and where it shows that also the city staff who were reviewing that case also deemed that the CLNU could not be approved because there was never a legally established use. Therefore, there cannot be a legally non-conforming use. Talking more about the CLNU appeal, they're going to talk a lot about the reliance on the 2018 STR ordinance to complete this work. And again, from a planning perspective, this substantial conversion thing does not automatically result in non-conforming use because we have to consider if the use is permitted by right, if there were any other type of zoning approvals or building permits or business license or anything like that needed to be done to secure those rights. And we believe that there are several, other sources, in the zoning and development code and other things that we've reviewed, like some of the case law that they provided that also reaffirms that, where it says that a valid non-conforming use is the use of a property which has lawfully existed prior to the enactment of the zoning ordinance and is a vested property right. So there's a lot of information. To summarize what I said, the property, did not obtain an STR permit, so we believe there's no lawfully established use. From a planning perspective, the substantially conversion topics for a property for an unpermitted use, does not automatically guarantee non-conforming rights. that the building improvements, could also be very appropriate, for a long-term rental or any other type of permitted use or one that needs zoning approvals. And as a reminder about the appeal review criteria, is that an appeal may be sustained only if the Board of Zoning Adjustment finds that the administrative official have erred. In this case, it's the development and code compliance staff. And for all of the reasons I said about like the code and the prior permit history, we do not believe that they have made an error. So that concludes my presentation. I'll be happy to answer any questions.
Thank you, Anna. This is very comprehensive and appreciate your work on that. Board members, questions of Anna? So it's your understanding, Anna, that there was no short-term rental permit ever applied for?
Even when they were able to.
Right. Okay, thank you. Mr. Gorns?
Question, there's 3 separate units, correct?
I believe there's 2.
2, okay. How about parking? What do they have a plan for parking?
I would let Mr. Taylor answer that. I'm not sure.
Yeah, can you hear me?
Yes.
Yes, we do. Each unit has a dedicated parking space to the rear of the building.
So for 2 guests or 1 guest, either way, they'll be able to park?
Yeah, we have 4 total in the back of the building, 1 for each commercial business, and then 1 space for each apartment.
Thank you, Mr. Taylor. Ms. Otto, did you have a question? I'm sorry.
No, I'm weighing.
Okay, great.
Everything that Anna said.
All right.
Timeline.
Great.
I'm reviewing the applicant's, what I would call a legal brief.
Thank you.
Judge McKenzie had said, so no, not at this time.
Okay. Okay. Any other questions? Otherwise, we'll turn it over to Ms. Duma.
Thank you. Board members, thank you for hearing us today. As some of you, probably 3 of you, have been with me through a lot of these short-term rental cases, and they made their way, and Mr. Allegri and I have been litigating these issues in front of Judge McKenzie. And what Anna said with respect to the law, that no legal established use means no non-conforming use, is not the law, according to Judge McKenzie, who issued an order regarding these types of cases. And so what the law is for a property that had started converting to a use and then the law changes during that time period is that they do have legally established rights if they substantially converted the property. And that's something more than just getting permits don't even matter, in fact, according to Missouri law, because that makes sense. Because imagine something is going to be illegal and you want to run to the permitting department to get that permit, even though you've spent no money, no time, and built nothing in real reliance upon that law. So the permits really are irrelevant. What's relevant is how much time, money, and effort and how far along the process that the applicant was when the law changed. In this case, he had spent over $1.7 million converting this dilapidated building. Structurally, it was, and a lot of those on Southwest Boulevard, a good friend of mine has one, structurally, they need help. You have to put a ton of money into them just to get the structure back. And then he did spend a lot of money fire sprinkling. And I'm going to have him talk to you for direct testimony about what the difference is between long-term rental finishes and short-term rental finishes, or office build-outs and short-term rental finishes, because there's money and investment that's spent specifically for short-term rentals and was part of his plan that would not have been spent for long-term rentals. And I'll have Mr. Taylor speak about that. But I want to start really clearly with what the law is. And I included in the documents Judge McKenzie's order. Just because he did not get this administrative permit does not mean that he doesn't have vested rights. That is where the city staff's representation of the law is incorrect. And so let me tell you a little bit more, stepping back, just kind of the process for Mr. Taylor. Mr. Taylor is a commercial airline pilot, previously a police officer, and he made investments in Kansas City. He lives with his young son and wife in Arizona, and uses property management companies that are reputable here to make sure that everything's taken care of for short-term rentals. But in 2018, he began looking at this property on Southwest Boulevard. And he, as part of his plan to make it make sense for dollars and cents, he got a commercial appraisal by Bliss Appraisal, Matt Woods, great guy. And they looked into what a short-term rental could make. Now, that wasn't just to see if it could make dollars and cents. These are documents used to get funding for loans. So when you build it, that your bank knows that it's going to actually make the money that you say it's going to make, not the money of a long-term rental, not the money of the fleeting offices, which are all going under right now across the nation, not the money of a condo that you'd have to sell potentially. So those were not the options Mr. Taylor was looking at. He specifically wanted those 2 units to be short-term rentals. And he purchased the property in 2019, immediately began getting all the permits and plans together to get the property renovated and to create the commercial on the first floor and the residential short-term rentals on the second floor. And mind you, we're on Southwest Boulevard at Broadway and Southwest Boulevard. So we don't have this is not a residential neighborhood. This is zoned M1, okay, manufacturing business type stuff. Why that's important is because we talk about this permit that he should have gotten. It was not the type of permit where you needed 55% neighbor consent. It was not the permit where you needed to do anything except for go down or fill it out on Compass KC. And so it was, although not by right, as close as by right as you could possibly be, because it was literally just a rubber stamp because of the zoning. There was no special, additional steps that he would have had to take. So why would a man spend $1.7 million on a property and not just fill out a form that cost $120? Here's the reason. When he got to the point where he was ready to launch his short-term rental, which I believe was a little later than late 2022, he hired a property management company that told him that for business zone properties like his, that permits were not required. This is something that have been echoed with other clients that I've personally had, that when they went to city planning and development, someone there told them, your business, don't worry about it. You're not residential. So that's what his property manager told him. And so he thought, okay, I don't have to, I can just start being a short-term rental. And it wasn't uncommon during this time period, because as the city auditor's report found out about short-term rentals, only 8% of all short-term rentals in Kansas City, Missouri were compliant. And that was a problem. That's why the law changed. But it wasn't unreasonable for people not to know. Certainly, it wasn't unreasonable for Mr. Taylor to know when he sought out that information. When he did hear about the law potentially changing or something going on with short-term rentals, he did call city planning and development. He's not lying about this. He showed me not a call log, but when he searched on it on his computer, it was on April 4th, 2023. And they said, just wait, the law is changing anyways. You can just apply after the law changes. And so he thought, okay, I'm good, without, kind of going further there. So I guess what becomes really important for you guys to evaluate and make a factual decision on is, did he substantially convert his property in reasonable reliance that the law would remain the same? And I do have a handout for you guys of a timeline, if I may approach.
Sure. Yeah, that'll be fine. That'll be Exhibit 11, as I recall. I'll just take a second. Thank you, Ms. Duma. Admitted as exhibit number 11. Thank you.
Thank you, Chair. So this is kind of what we went through with the final hearing with Judge McKenzie. And that hearing was about 2 months ago. And I have reached out to the court, and we don't have an opinion yet from him. But his early order, when I was seeking a temporary restraining order, did define this as the law to follow. Not, they didn't have a permit, so they don't have rights. This is what Judge McKenzie said is the law. So the first element is substantial conversion, and this is based on the cases of Outcome, Claudia Lee, and Lamar, which are cited in the brief that I submitted. Of course, just buying a property in hopes of having it be an STR as we go along the timeline here, that's not enough. That's not enough substantial conversion. Just wanting one, not enough. Just buying a property and getting a permit, not enough. So Then you move along. You hire your architect. You prepare the plans. You go through all the process of getting ready to start building. You go to the city, and that's long and laborious. Then you actually do the renovation, the structure. You finish everything out. You fire sprinkle, plumbing, electric, HVAC. This is a lot of money and a lot of work. Okay, and then why these ones on top are bigger is because that's where the heavy lifting is, okay? To be an STR, like my bedroom in my house, if I wanted to just go take a picture of it and put it on Airbnb, technically could be an STR, right? I could rent out that room at any point until November 1st, where I live. But then the process continues, furnishing it, getting it photo ready, creating a listing on Airbnb and applying for an STR permit and then getting booked. Really important here. On most like of these permits or like when you get a building permit, you have to go to the building code before you build it. You have to go to the building department before you build anything, or they could make you tear open walls and make sure what you did was right. Short-term rentals are different. The permit was like the last thing that you did because you had to have certain things that were guaranteed as part of even applying for a permit. You testify, sign an affidavit saying, I have, running water. I have a flashlight in there. I have a what's it called? Fire extinguisher, things like that. So it was not uncommon for people to not get their short-term rental permits until the very last thing because they had to go do, especially on these renovation projects, because they had to do everything first. They didn't need permission to do it, nor could they really legally get it because they had things they had to say they had to do. So as we go here, the substantial conversion, Mr. Taylor, before the law changed, did everything and it was ready to go. He had those vested rights. He substantially converted that property. It is completely clear from the timelines on everything. Now, as we go to the next page, this is also kind of give you a timeline of what's reasonable, right? So this is when he did everything. October 14th is 2018 is his commercial appraisal. Purchased it in February 19th, 2019. June 2022, he received his certificate of occupancy. September 2022, he believed that no permit was required because of the zoning, and his property management told him that. April 4th, he called the city and said, no, don't do it yet. Law's about to change. Just wait. So from 2019 to 2023, that's when he spent $1.7 million improving this property on Southwest Boulevard. Now, what happened with respect to the change in law is in red to the right in 2023. The audit results came back on December 1st, 2022. That determined that there was only 8% of all short-term rentals that were compliant. March 1st was the first City Planning Commission hearing where the first draft of the new ordinance was released. Nobody would have reasonable knowledge that the law was going to change until then, and that's assuming someone listens to City Planning Commission hearings, the reasonable person. On April 4th, the voters approved a tax on short-term rentals, which meant to a lot of people that Kansas City, Missouri wanted them. They just wanted to tax them like hotels. On April 29th, there was the public hearing about the new ordinance, which outlawed short-term rentals in Kansas City, Missouri. And on May 4th, the council passed that ordinance. So that happened all in early 2023. Everything that Mr. Taylor did was from 2018 to 2023. He was not trying to skirt getting a short-term rental license. Someone doesn't invest $1.7 million in a property and then forego an administrative one-page document that would have absolutely had to been processed. There was no, is it complete? It is fill it out and it's complete. Like this was not like where you have to have the adjacent neighbor signatures, and it was a whole other process. So I'd like to briefly ask Mr. Taylor a couple of questions. And Mr. Taylor, can you please explain to the board why you did not obtain a short-term rental permit in 2022?
Yeah, absolutely. The reason we didn't obtain the permit in 2022 was because we were under the impression from our property manager that one was not needed due to the fact that we were not in a residential district. The understanding was that we had operated an Airbnb on 39th Street since 2019, and that was also in a business district, and they didn't get a permit for there. We had been operating for many years without any enforcement action from the city, so we were under the assumption at the time that we were legal to do the same thing on Southwest Boulevard.
Thank you, Mr. Taylor. And can you please explain for the board extra expenses that you went to when converting this to a short-term rental specifically as to other uses like a long-term rental or an office building?
Yeah, an office building
I'm
or
sorry.
long-term.
What are the expenses you went to make it a short-term rental specifically?
I think that I heard the city say that it could be a long-term residential rental. And I can assure you that financially, yes, it legally could it be? Yes. Financially, would it have been? No, that would have been not a great decision at all because the cost to renovate that building were so substantial. It was, a 100-year plus over 100-year-old warehouse that had been kind of dilapidated and needed all new structural work, plumbing work, electrical work. So when I'm investing all my time and money and the bank's money, because I had to have a loan to do this project that I'm responsible for. The income generated from commercial or long-term residential rentals do not, number one, the bank would never have loaned me the money to do the project if that was the case, because it wouldn't have paid the bills. And number two, I would be losing a substantial, all my investment plus some, and plus the mortgage that I have taken out. I wouldn't be able to pay those bills if it was a commercial or a long-term residential rental. So I would never have even started the project had that been the case.
Thank you, Mr. Taylor. I'd also like to just comment on the city staff's kind of saying or alluding that he's illegally operating. He's not. No, he does not have a neighborhoods permit yet, but we have our hearing on that appeal tomorrow. They have stayed the case pending the decision on the legal nonconforming use. That way we didn't waste two boards' times. So in conclusion, please look at the substantial conversion and the reasonable reliance in the timeline and the amount of money invested in Kansas City, Missouri by Mr. Taylor. And please overturn staff's decision denying the legal nonconforming use.
Questions?
I have a few, yes. So Ms. Duma, you admit that at the time your client purchased this property, that there was an ordinance in place that regulated short-term rentals.
Yes.
And you will agree with me that Judge McKenzie in his order, the facts of the applicants involved in that order all had properly applied for applications under the 2018 ordinance, correct?
Yes. I do have a comment on that, though.
Okay, let me ask my questions.
Yeah, of course.
I'll be happy to listen to you.
Okay.
But I want to make sure I understand what you're arguing here today. So, you will admit that the applicant did not start renovations, didn't purchase this property until 2019, correct?
That's correct.
And the 2018 ordinance was still active and in place at that time.
That's correct.
Right.
I was just going to say there was a lot of discussion with the city attorney and I with respect to the relevance of applying for a permit. And the city argued, and I agreed, the application for the permit in and of itself means almost nothing.
Okay, what do you, I don't understand.
Because it has nothing to do with whether or not you had a permit. It has to do with the steps you took to substantially convert to the use.
I am not focusing on the permit, Ms. Duma.
Okay.
I'm focusing on the fact that there was in place an ordinance that clearly put your client on notice that there was a process for which he should have taken advantage of. Judge McKenzie is clearly saying that people had applied for that and had done some work. I see your client in a little different legal position. So that's what I'm trying to understand the argument. And then I have another question. Go ahead.
I just want to jump in and say that's not something that I've said, and I don't want to be mischaracterized by her summation of that. So if you have questions about what I think about it, we can go in a closed session, but
Ms. Otto, can you speak closer into the microphone?
I'm sorry. Yeah, sorry. I twinged my back right before I came into this meeting, so it hurts, and that's why I'm sitting back. I'll sit forward. What is the status of the order in front of Judge McKenzie? Is that on appeal or is it final?
That was an order for temporary application for a temporary restraining order. We are waiting for his final order. We had our hearing 2 months ago.
Okay, so it's still within the circuit court and it may go on appeal then, Ms. Duma?
Yes.
So we don't really have a final order from the judge on this?
No.
So this is not precedential law that you presented to this board?
Well, I think it's good guidance on what the judge that hears appeals of this board is leaning towards. And the court did note that it was kind of there were some issues of first impression. I'd love to have Judge McKenzie's final order just for guidance. And I've asked for it, but we don't have it yet.
I do have a quick timeline question. I've seen the staff's timeline and your timeline, but the one event that I'm not seeing on here is when did the first guest stay at the property?
Mr. Taylor, can you speak to that?
I think it was September of 2022.
And so that was
Because
under the
we,
old code.
Sorry,
yes,
sir?
it was under, yes, it was under the old code. And I don't know if the board remembers, but I had another short-term rental on 39th Street that we had acquired in 2018, but that one had been operating as an STR since like 2014, 2015. So we had kind of, although that's where my impression of the short-term rental laws that come from was from that first acquisition that relied on that previous timeline prior to 2018.
Mr. Taylor, is that the STR above the bagel shop on 39th?
Correct, sir.
I would like to move to go into closed session.
Do you want to see the
Magic words?
it is?
I would move that the board go into closed session pursuant to section 610.021, subsection 2 of the Missouri statute.
I have a motion by Ms. Otto. Do I have a second?
Second.
Please call the roll.
Gorens,
Aye.
Mixdorf,
Aye.
Otto,
Aye.
Wright,
Aye.
Ebbets.
Aye. We'll be back in a few minutes. Okay.
Oh, thanks.
Second.
Please call the roll.
Gorens,
Aye.
Mixdorf,
Aye.
Otto,
Aye.
Wright,
Aye.
Ebbets.
Aye, we're back into open session. We had some legal advice pursuant to that closed session. And Ms. Otto, I'm going to let you take the lead on this since you are our legal person at the board.
Okay. I don't think I need any other evidence from the applicant, but before I would make a motion, I would want my fellow board members to ask any other questions they have of the applicant or the applicant's attorney. Okay. Then, Mr. Chair, if there's no other questions.
Go ahead.
I am ready to make a motion in this case. I move that the decision of the staff be upheld and the applicant's request be denied.
I have a motion. Do I have a second?
Second.
Please call the roll.
Gorens,
Aye.
Mixdorf,
Aye.
Otto,
Aye.
Wright,
Aye.
Ebbets.
Aye.
Thank you.
Thank you.
Jumping to docket number five, I think.
Docket item.
Oh, just continue.
Docket item number 5 is case CD BZA 2025-114. A request to approve a variance to permit an accessory structure to be closer to the primary building, plus any other needed variances in an R6 zoning district on about 0.24 acres, generally located at 7713 Madison Avenue. The staff planner for this case is Stephanie Saldari. If you are the applicant or you're the applicant, you can come and be seated at the center desk. You are a member of the public who would like to speak on this case, please raise your hand online or approach the microphone on the podium to be sworn in. We do have a hand raised online. I will promote Joe Rathermel to panelist. And you can approach the.
I'll swear you in just a second. Thank you. We have an online Joe, correct?
Yes.
Okay, thank you. Anyone else out there, Sarah?
There are no other hands raised online.
Okay. Joe, could you turn on your camera and microphone? I think I see you there. Joe?
Yep, he's there.
Can't hear him.
Could you turn your microphone on, please?
Can you hear me now?
Perfect. Thank you. Everyone, please raise your right hands to be sworn. Do you solemnly swear or affirm to tell the truth and nothing but the truth in this meeting today? If so, please say I do or I don't, and your name and address. Let's start with the people at the table first.
Hello, I do. My name is Josh Lacey. I'm homeowner at 7713 Madison.
Thank you.
I do. My name is Anna Lacey, address 7713 Madison.
All right. You?
Jeff Shifley, address 900 West 77th Terrace, 64114. I'm
Jeff.
directly across the street from them.
Perfect. And the online person, Joe?
Yes, Joe Rathermo, 5990. I do. 5990 North Saline Avenue, Kansas City, Missouri, 64115.
Thank you, Joe. And are you in support or opposition to this request?
He's the applicant.
What?
He's the
Oh, he's the architect. Thank you. And Jeff, opposed or support? Support. Okay, thank you. We'll give you a chance to testify in a minute. And who's speaking for Josh and Anno? Josh is?
I will. Yeah.
Great.
Thank
Josh, there are lists of administrative exhibits associated with your case. They are labeled 1 to 9. Do you have any questions on those exhibits? And if not, do I have your permission to admit those?
I do not. And yes, sir, you do.
Thank you. Those are admitted. Part of that is a presentation by Ms. Saldari. Stephanie, please tell us about the case.
All right, we got docket item number 5, CDBCA 2025-114, located on 7713 Madison Avenue, Zone R-6. And the applicant seeks to obtain a variance to permit a smaller separation distance between an existing detached garage and the principal structure. The rear of the principal structure suffered damages from a fire, and the owner would like to rebuild this portion of the house, but also add a second-story addition. The subject site is located down around the Waldo neighborhood. Highlighted in yellow is the subject site. This is that garage that we are speaking of. So this is the site plan. So if that addition is built, it would leave a 6.8-foot distance between the existing garage and the principal structure. And the zoning code requires at least 10 feet. And this is the rear elevation of the house or the proposed. And then these are photos of the rear of the house. You can see the fire damage up on the roof and the outside. This is another photo. And then this is a photo showing that distance between the garage and the principal structure. So we have one variance request today. So this is a variance of 3.2 feet to the accessory building standards to permit a separation distance of 6.8 feet on the subject side per the submitted site plan. This is a 32% decrease. A change to the character of the neighborhood is not anticipated since the detached garage has been in existence for at least 20 years. This is based off how far parcel viewer goes back in the aerial view. And just like a little background on the code. So per 88-6-1005, so non-conforming structures. In this case, it would be non-conforming because of that 6.8-foot distance. They can be rebuilt if less than 50% of the building was damaged due to fire, weather, something out of a person's control. However, in this case, because of that addition, you're adding to a non-conforming building. So now that legally non-conforming building, it brings it further out of non-conformance. So that triggers a variance. If the addition was not being built, then they would be able to build that portion that was damaged in the fire outright and would not need any variances. So this is why we're here today, due to that addition. And that concludes my presentation.
Thank you. Questions by board members of staff? Seeing none. Josh, why should we grant your request today?
Well, what has happened is we had this electrical fire a year and a half ago. Well, May of 24. Our family, since we've owned this home for more than a decade, it's the only property we own. Our family's grown. We have 3 kids. We used to have 1.
Congratulations.
And that 1 was a half timer. So we've got 3 full. We got a family of 5 now. We've grown. We had this fire. And this is a way to take advantage of the property for our needs. We're not trying to get a short-term rental room. We're not trying to rent this out. We just want to get back into our home. We've been out for years. Now, this addition on that, where that roof was burned off, you saw in the picture there, was really the only feasible way we could see to expand without changing the footprint of the house, which is block and stucco. The garage is also concrete block. So modifying the footprint of these structures would be cost prohibitive, and really put us in a bad spot where we'd have to be thinking about selling rather than rebuilding.
The only variance request is the distance between the garage. and the
3.2 feet.
Correct?
Correct.
Right.
Yeah.
I have a motion.
Do we want to hear from the other audience members?
Yeah, let's hear from Jeff.
Yep.
Joe and Jeff, quick comments. And-
Sorry, I'm
and-
taking my, seriously.
And before that, we gave a variance at 74th and Madison a couple of years ago on a garage.
Oh.
Or is that, well, that could be him. Okay. I'm
That
sorry,
wasn't
Jeff,
me,
go ahead.
But
This board has listened to these variants, because you can, go ahead.
since the fire's been there, it took a big chunk of the tree out. So this is actually going to fill that spot up quite nicely. So
Right.
the second floor is going to really fit in well. So
Thank you, Jeff, for your good support. I appreciate it.
Thank you.
Joe, you want to say anything quickly? The architect?
I don't have any comments. I think Stephanie and Josh did a great job covering everything, but I do want to thank you, Stephanie, for all of your help and for the board for hearing our case.
Okay. Ms. Otto, did I hear you have a question or a comment or a motion?
I want to cut off my board members. They all have questions, sorry. This is what happens when you've been on this board for 28 years. You take a couple years off and you come back. Your brain just, you go to this pretty quick, sorry.
Well, you're in charge.
No, I'm not. He's in
Oh, you were
charge.
then.
I was in charge, but I'm glad he's in charge now. Anyway, on docket number 5, case number 114, I move that we grant the applicant's request for variance in accordance with the staff report and site plan.
I have a motion. Do I have a second?
Second.
Second from Mr. Gorens. Please call the roll.
Gorens.
Aye.
Mixstorf.
Aye.
Otto.
Aye.
Wright.
Aye.
Ebbets.
Enthusiastic aye.
Good job, guys.
Good job. Thank you.
Enthusiastic, thank you.
Good luck with your rebuild, and I hope you
Okay.
get home soon.
We're approaching our 10:30 break time. Do we want to take one more? You want to go back?
Let's do one more. so
Let's do one
take a
more.
break.
Okay.
I mean, yeah.
Good.
Thank you, guys.
Docket item number 6 is case CD BZA 2025-118, a request to approve a variance to features allowed to encroach on the front setback, plus any other needed variances in an R6 zoning district on about 0.08 acres, generally located at 700 West 44th Terrace. If you are the applicant or a member of the public who would like to speak on this case, please approach the microphone on the podium or raise your hand online to be sworn in. Joan Pearson and Ken Pearson are both online. I'm promoting them to panelist.
Please turn on your cameras and microphones. I can swear you in.
And video.
There you go.
Do you want to come over?
Just one of you.
No, we're both here.
Oh, you're both
You
there.
need to
Turn yours up.
Say something else so you don't echo.
Okay, we took care of it.
Okay, great. Thank you. Please raise your right hand to be sworn. Do you solemnly swear or affirm to tell the truth and nothing but the truth in this meeting today?
Yes,
I do.
I do.
And please state your names and address for the court reporter.
Joan Pearson, 700 West 44th Terrace, Kansas City, Missouri, 64111.
Ken Pearson, 700 West 44th Terrace, Kansas City, Missouri, 64111.
Thank you. There's a list of administrative exhibits labeled 1 to 9 that we need to admit for your case today. Do we have your permission to admit those?
Yes, you do.
Part of that is a presentation by Ms. Saldari on your case. Please tell us about it.
Okay, we have docket item number 6, CDBCA 2025-118, located on 700 West 44th Terrace, Zone R-6, and the applicant seeks to obtain a variance to permit a balcony and stairs to encroach on the front yard. The single-family building has already been constructed. And the subject site is located in Midtown. So a little bit of background, you might, some of the board members might recognize this area from about 2 years ago. Anna did multiple, like 20-something variances in this neighborhood. Some of the property owners were not all able to get in on this case at that time. So the property owners for this location are doing it now, but they will be the same variances essentially. So this is the site plan. The two features encroaching are the balcony and the stairs. And this is just, I just zoomed in because it was hard to see on the other slide of the stairs and the balcony. This is what the front of the house looks like. The garage is like ground level, but then the rest of the house is above the garage, so you need like a tall staircase to get there. This is a much better image. And then this is just those variance case from 2 years ago for this whole neighborhood. So variance request A is a variance to the encroachment standards to permit stairs above 6 feet in the front yard on the subject site per submitted site plan. It is a complete deviation. Change to the character of the neighborhood is not anticipated since 26 of the surrounding properties in this neighborhood received the same type of variance. Can the difficulty be obviated? So no, the building is already constructed. A zoning review did occur during the building permit phase, and the need for variances was not identified until late 2022. Variance request B, a variance to the encroachment standards to permit a balcony in the front yard on the subject site per submitted site plan. Again, a complete deviation. It still does not change the character of the neighborhood. And again, the need for the variances were not identified until later, until after the zoning review was conducted. And that concludes my presentation.
Thank you, Stephanie. Questions, Ms. Salderi? So again, Stephanie, this should have been maybe included a couple of years ago, but for some reason it wasn't, and now they're here today.
Yeah, I'll let the applicants talk more about that.
All right. So either Ken or Joan, tell us why we should grant your request today.
Well, we were unable to join in 2023, and basically we would like to take care of that now. Do you have any questions for us? The original hearing was May 30th, 2023, when all of the people joined were granted the variances for these issues. We just want to be in compliance as well.
All right. Board members?
Stephanie, are there other homes that have not gone through this process, or would this be one of the last remaining homes that was not caught in that initial review that was brought before us?
I'm not 100% sure, but I think they may be one of the last ones. I don't think there's other ones.
Seems pretty straightforward. Board members, questions or motions?
I'd offer a motion.
Thank you.
In docket number 6, case number 118, I move we grant the applicant's request in accordance with site plan and staff report.
I have a motion. Do I have a second?
Second.
Second from Ms. Wright. Please call the roll.
Gorens,
Aye.
Mixdorf,
Aye.
Otto,
Aye.
Wright,
Aye.
Ebbets.
Aye. Your request has been granted. Thank you very much for coming before us.
Thank
We're gonna
you.
Thank you.
take a quickie 10-minute break. We'll be back at
Okay.
is it,
I get out of that.
10:50.
Still don't believe it.
I know you do.
Thank you.
That's a
We
good thing.
like that.
Yeah. Go right ahead.
Like, was it I think it was Slovenia.
Okay, we good? All right, we're back into session after our break. Please call the next case, Sarah.
Oh, I'm on the wrong page.
Number 7.
Docket item number 7 is case CDBZA 2025-93, a request to approve a special exception to permit a taller fence on the street side yard, plus any other, I'm on the right case, right? Plus any other needed special exceptions in our 7.5 zoning district on about 0.3 acres, generally located at 2 East Bridle Spur Avenue. Stephanie Saldari is the staff planner for this case. I have Anthony Spolito, the property owner, online. I'll promote you to panelist. Any other members of the public who would like to speak on this case, please raise your hand online or approach the microphone on the podium to be sworn in. There are no other hands raised online. Anthony, if you would please turn on your microphone and camera to be sworn in.
Can we hear you yet, Anthony? I see your face.
I am here. Sorry about that. I was actually there in person. I just had to get back to the pharmacy. But I appreciate you guys taking the time.
All right, don't say more. I got to swear you in.
Sounds good.
Don't say more. Thank you. Please raise your right hand to be sworn. Do you solemnly swear or affirm to tell the truth and nothing but the truth in this meeting today? If so, please say I do or I don't, along with your name and address.
I do. Anthony Spolito, 2 East Bridle Spur Drive, Kansas City, Missouri, 64114.
Thank you, Anthony. There's a list of administrative exhibits associated with your case labeled 1 to 10. Do you have any questions about those exhibits? And if not, do I have your permission to admit them?
I believe so, yeah. I don't have any questions in regards to them.
Okay, so we do have your approval then? To admit
Yeah.
them? Great.
Yes.
Those are admitted. Part of that is a presentation by Ms. Soldari on your case.
Okay.
All right, we got docket item number 7, CDBCA 2025-93, located on 2 East Bridle Spur Drive, zone R-7.5, and the applicant seeks to obtain a special exception for an existing fence in the street side yard. All right, so the subject site is located just south of I-435. And this highlight in yellow is the subject site. You can see this line here, that is the fence in question. And so the only portion of the fence that is non-compliant according to chapter 27 is this little portion right here on the side of the house. And that portion of the fence, you can see it from here. Right now it's at 6 feet. That portion of the fence is where some utilities are at. And I will let the applicant speak more to this, but this fence has been in existence for about 40 years. So this is a special exception of 2 feet to the fences and wall standards to permit a 6-foot fence on the street side yard of the subject site per submitted site plan. This is a 50% increase. A change to the character of the neighborhood is not anticipated, so this fence has been in existence per the applicant for around 40 years. It has not been an issue for neighbors. Plus, the fence is set back from the street, so it does not cause any visibility issues for the oncoming vehicles. And that just the fence could be reduced to 4 feet. And that concludes my presentation.
Thank you. Questions of Stephanie? Anybody? All right, Anthony, why should we grant your request?
Well, it's my grandmother's home. We have a pool in that backyard, and as you saw in that presentation, there's a lot of pool equipment that, honestly, upon measuring it, it's right at just above 4 feet. So taking that down, I don't really think aesthetically, I assume, is why this was brought up in the first place, because I don't really see, like you said, there's no hindrance to any vehicles or anything that would cause an issue with neighbors. And I feel like just lowering this fence, not only does that make the pool equipment less secure and, safe, to not be tampered with, it also would just create an eyesore for the neighbors because then they would be forced to see all of that pretty old equipment instead of the fence, which right now is guarding and protecting that at 6 feet. It's also connected to the rest of the fence that encloses the entire backyard, which I have pictures in this presentation that show that. And aesthetically, I just don't see how that would be an improvement for anybody. And, something my grandma just does not really want to do. She's 84 years old. She was taken completely off guard by this. So she doesn't know how to use Zoom. So she's kind of a nervous wreck, and I'm just trying to help her out a little bit and try to get this passed where we don't have to lower that. Also, yeah, go ahead.
I was just
Well,
gonna say, so
also really quick, it would also kind of hindrance the privacy of the property, in my opinion. So, and to my grandma, that is important, having privacy in her backyard. So go ahead, whatever you were
I was
saying.
just gonna ask, so she lives in the house, or do you live in the house?
She does. She does. She also has a place up north that she stays at, on occasion. And, it's kind of been a family home. My grandpa built that home, I guess, 50 years ago. And that's kind of a gathering place for all of our family to go over there, swim, and, never had any issues in the neighborhood. I don't know why this all of a sudden got brought up. It's been there for 40 years, that fence, without any issues. But, again, she's just not very technologically advanced. She has very long nails. She can't even type in a phone number on a smartphone. So that's why I got the affidavit, and I'm trying to help her out with this request.
Anthony, this is Teresa Otto. Has there been any crime in that neighborhood? Has she had any break-ins, anything attempted?
We actually did have a break-in. This was probably 4 to 5 years ago now, where someone did come in through the fence backyard. They hopped over the fence. I don't think, this would just make it even easier for someone to hop over the fence. And then they broke into the door that goes into the garage from the backyard and stole some really important documents and, memorabilia things of my grandmother, which is just terrible. Ever since then, we've kind of tried to re-secure that fence. So just like getting this request, that's another, she's very nervous about that break-in that occurred. Thankfully, she wasn't home when it happened. And just the thought of lowering a fence was just going to make her feel less safe. And we don't want that. So hoping we get this approved.
I'm not on this quorum, but I'm a big fan of not undoing long established things for the sake of it. But I think maybe for the sake of being thorough, perhaps we could pull up the aerial view of this property and pull up the past aerials just to establish that this is a long existing fence.
This be another exhibit?
I think all of it was attached to the original. And Stephanie, I did send you some extra photos this morning when I was in there. I don't know if you received those on email or not, but the aerial is included in that original form I sent.
Yeah, if
I'm
you change
sure-
the base map,
Yeah.
you can change it to like.
Yeah, let's start. So we got,
Been there for 40 years. You can go back as far as.
you can see it
Yeah.
here.
looks like
Here, if we go
that's-
back to 2006, you can see it here as well.
So the fence is at least 19 years old.
Minimum. I mean, I think it's closer to 40, to be honest with you, but
20.
Ready for a motion?
I sure am.
Okay. In docket number 7, case number
93, I move that the board grant the special exception request of the applicant in accordance with the staff report and site plan.
I have a motion. Do I have a second?
Second.
Second from Mr. Gorens.
Gorens,
Aye.
Mixdorf,
Aye.
Otto,
Aye.
Wright,
Aye.
Ebbets.
Aye. Your project is approved. Thanks for coming before us, Mr.
Yep.
or Dr. Spolito. Thank
Thank
you.
you, sir. Stephanie,
Yes.
thank you so much for your time as well. Appreciate
Anthony,
it.
how's your
Thank
dad,
you.
Anthony?
He's doing good.
Good.
Yeah. Who is this?
Tom Gorenc.
I'll tell him you said, okay, what's the last name?
Gorenc.
I'll tell him you said hi.
Okay, thank you.
All right. Thank you. Bye.
Next case, Sarah.
Docket item number 8 is case CD BZA 2025-120, a request to approve a special exception in an R6 zoning district to permit a fence at a height of 6 feet, plus any additional variances on about 1.38 acres generally located at 450 West 51st Street. We have Jeffrey Schutzler, the applicant, online. I'm going to promote him to panelist. You are a member of the public who would like to speak on this case, please raise your hand online or approach the microphone on the podium to be sworn in. Janelle Agnos, I'll promote you to panelist.
Hello.
Hey there. Do we have anyone else that you see?
No, just those two.
Great. Can you raise your right hand to be sworn? Do you solemnly swear or affirm to tell the truth and nothing but the truth in this meeting today? If so, please say I do or I don't, along with your name and address.
I do. Janelle Agnos, 400 West 51st Street, Kansas City, Missouri, 64112. I am the school's representative.
Thank you, Janelle.
Jeffrey Schutzler, I do. I'm the architect.
Thank you. Who's speaking on the case? Jeffrey or Janelle?
I will.
Okay. There's a list of administrative exhibits labeled 1 to 9 associated with your case today. Do we have your permission to admit those?
Yes.
Great. Part of that is a presentation by Mr. Tomlin. Connor, please tell us about the case.
Okay, we have docket number 8, CD BZA 2025-120. This is located at 450 West 51st Street in R6 zoning district. The request is a special exception to permit a fence at a height of 6 feet on the subject site, plus any additional variances. This is the general location of the site. A closer look at the site outlined in yellow. This is similar ownership with the school to the east. This is the mock rendering that was provided, showing what the fence would look like if approved. And then I have a couple photos here of the property east and west of the subject site. That first image on the left-hand side is looking to the east of the subject site, looking at the sports field for the school. You'll see that there's a 6-foot fence already existing there. We're unsure if there was previous approval of this further back, but we didn't have documentation digitized to look in time, and we weren't able to request the files in time for this meeting. And then that right-hand side image shows the property to the immediate west. The request is a special exception in the amount of 2 feet to the maximum height of a fence to permit that fence to be 6 feet in height. That's a 50% increase. Substantial change to the character of the neighborhood is anticipated as fences, specifically for houses in this area, appear to be compliant with front yard fence requirements. The Pembroke Hill School sports field to the immediate east, as you saw in the previous image, has a fence of similar material that exists at a height of 6 feet. However, again, we're not sure if this had prior board of approval. Back in the day, we just didn't have the files in time to check that. The difficulty could be obviated through a change of design, such as reducing the fence to a compliant height of 4 feet. And that concludes my presentation.
Thank you. Jeffrey, I err. There were 10 exhibits labeled 1 to 10. I need your permission again to admit that 10th exhibit.
Yes, that's fine.
Thank you. Those are admitted. Board members, questions, Mr. Tomlin? And Jeffrey, the fence height will be similar in height or exactly the same as the fence to the east of the property. Is that right?
That is correct.
Right.
Have you received any comments from neighbors?
No, we have not.
And the headmaster lives in this house, in this home?
That is correct. Yes. The headmaster's residence is directly adjacent and contiguous without a fence separating it from the rest of the campus, and it is owned by the same school entity.
Janelle, do you have any comments?
I do not.
Okay. And it will be the same material, kind of see-through, so to speak. Isn't that right, Jeffrey or Janelle?
That is correct. It will be a similar material as the existing fence that is along the south portion of the athletic field. That is actually a wrought iron fence. The new would be more of an aluminum style, replicating that look.
Right. Board members, questions or comments or motions? Seems very straightforward to me. Sure.
Yeah, I'll make a motion on item number 8, case number 120. I move that we approve the special exception in accordance to the site plans and the staff report.
I have a motion by Ms. Wright. Do I have a second?
Second.
Second from Ms. Otto. Okay.
Gorens,
Aye.
Mixdorf,
Aye.
Otto,
Aye.
Wright,
Aye.
Ebbets.
Aye. Your project is approved. Thank you very much for coming down today or coming before us. Thank you.
Thank you very much. We
Thank
appreciate it.
you.
Docket item number 9. This case CD BZA 2025-91. A request to approve multiple variances to accessory structures and gravel standards in an R6 zoning district, plus any additional variances on about 0.36 acres, generally located at 5106 North Brighton Place. Connor Tomlin is the staff planner, and we have the applicant here. If you are a member of the public who would like to speak on this case, please raise your hand online or approach the microphone on the podium to be sworn in. We have no other hands
No
raised.
other hands raised in the audience. Okay. Just a second. I'll be right there. All right. Please raise your right hands to be sworn. Do you solemnly swear or affirm to tell the truth and nothing but the truth in this meeting today? If so, please say I do or I don't, along with your name and address.
I do. Misty Jones, 5106 North Brighton Place, Kansas City.
Thank you, Misty.
Jason, I do. Jason Jones, 5106 North Brighton Place, Kansas City, Missouri, 64119.
Thank you, Jason. There's a list of administrative exhibits labeled 1 to 10 that are associated with your case. Do you have any questions about those exhibits? And if not, do I have your permission to admit them?
Yes.
Great. Those are admitted. Connor Tomlin is going to tell us about the case. Connor?
Okay, docket item 9, CD BZA 2025-91, located at 5106 North Brighton Place. This is an R6 zoning district. The request is to obtain multiple variances on the subject site after the applicant had received notice of violation. These variances include, but are not limited to, the driveway, gravel, accessory structure requirements, plus any additional variances. This is the general location of the site. A closer look at the site outlined in yellow. The site plan that was submitted, which I will revisit here in a little bit. Just for some context, this is what it appears as from street view, directly head on, and then from just to the west of the property. Variance request A is a variance of complete deviation to the parking and loading standards to permit gravel on the subject site. Again, this is a complete deviation. As substantial change to the character of the neighborhood is anticipated. This gravel has been located here since at least 2008 via Google Street View. However, this appears to have been completed without prior city approval from what I was able to find. The gravel is generally not encouraged to be approved on residential lots. Additional information and photos can be found under the variance review criteria in the staff report. The difficulty could be obviated through a change of design, such as removing the gravel and paving that section where the gravel is located. Variance request B is a variance of 23 feet to the maximum width of a driveway to permit a driveway width of 45 feet on the subject site. Again, that's a 23-foot variance or a 104.5% increase. A substantial change to the character of the neighborhood is anticipated. This driveway has existed similar to the gravel since at least 2008 at its current width of 45 feet. However, every other driveway width appears to be compliant in this area with the standards. This said, a driveway at this width would not have been permitted under prior zoning code, so I'm not sure if there was if there was approval back in 2008 or prior when this was constructed. And then approval of the variance for a driveway at this width sets a precedent for residential driveway variances in the future. The difficulty could be obviated by removing the excessive portion of driveway. Variance request C is a variance of complete deviation to the location of a detached accessory structure to permit a detached accessory structure in the front yard of the subject site. For reference, that is this carport in the front here that I'm referencing. That's a complete deviation to the location. Again, substantial change to the character of the neighborhood is anticipated. This detached accessory structure has existed since at least 2008 at its current size and location. However, again, I couldn't find evidence of city approval when it would have been constructed. Additionally, the character of this neighborhood is largely compliant with accessory structure standards and requirements. Again, approval of this variance could set a precedent for properties in Kansas City in the future that have similar structures. As always, the city recommends compliance with standards from the start rather than seeking variances after the fact. Again, this difficulty could be obviated through a change of design, such as removing the structure to abate the violation. Variance request D is a variance of 704 square feet to the maximum size of that detached accessory structure to permit it to exist at 904 square feet. That's a 351.7% change. A substantial change to the character of the neighborhood is anticipated. Again, it has existed there since at least 2008. However, it's very much in excess of what would be allowed by right for accessory structures as far as size is concerned, and approval of a variance would set a precedent for the size of structures in the future. The difficulty could be obviated through a change of design, such as removing it and replacing it with a compliant 200 square foot accessory structure. Variance request E is a variance of 10 feet to the separation distance between structures to permit a detached accessory structure to be 0 feet from the principal structure. Again, this is that same carport in the front yard. It is going right up to the house, so it'll need a 10-foot variance to that standard. It's a 100% change. A substantial change to the character of the neighborhood is anticipated. It's existed since, again, 2008, same thing as before. However, the separation distance requirements exist to prevent the event of a fire. Like if a fire were to occur, it would have a harder time jumping from structure to structure and spreading. The difficulty could be obviated through a change of design, such as removing the structure altogether from that location. Variance request F is a variance of 178 square feet to the maximum size of an accessory structure. It's in the rear yard. For reference, in the staff report, I have a diagram labeling each variance to its corresponding structure. And this would be to permit it at a size of 378 square feet on the subject site. That's an 89% change. Detached accessory structures appear to be generally compliant with size requirements in the immediate area. This specific structure has been in place since 2014 based on aerial imagery. However, that doesn't negate the fact that it's a non-compliant size. The difficulty could be obviated through a change of design, such as removing the existing structure and replacing it with one that is 200 square feet, which would be a compliant size. Variance request G is a variance of 178 feet to a structure in the rear yard, and this would allow it to be 378 square feet on the subject site. Again, that's an 89% change. This one appears to have been in place since 2018 based on aerial imagery. Again, does not negate the fact that it's larger than the size it would be allowed by right. Difficulty could be obviated through a change of design, such as replacing it with a structure that is of compliant size. Variance request H is a variance of 136 square feet to the maximum size of an accessory structure to permit a detached accessory structure at 336 square feet on the subject site. That is a 68% change. It appears that this structure has been in place since 2012 on aerial imagery. Again, does not negate the fact that it's a non-compliant size. Same thing as before, could be obviated through a change of design, such as replacing it with a compliant size structure. Variance request I is a variance of 6 feet 4 inches to the separation distance between structures to permit a separation distance of 3 feet 8 inches on the subject site, which is a 63% change. Most properties in this area appear to be generally compliant with separation distance requirements between structures. Again, as I said earlier, the purpose of the separation distance is to prevent the event of fire hopping if a fire were to occur. The difficulty could be obviated through a change of design, such as removing the structures or placing them elsewhere where they would meet this separation distance requirement. And then variance request J is a variance of 7 feet 8 inches to the separation distance between structures to permit a separation distance of 2 feet 4 inches on the subject site, which is a 76% change. Same thing as before, the area appears to be generally compliant with these standards, and the separation distance requirements exist to prevent fire jumping and allow a greater flow between buildings as you traverse between them. The difficulty could be obviated through a change of design, such as removing the structures or moving them to somewhere where the separation distance would be compliant. That is all of the variances that I have at this moment. Similar to what's in your staff report, I have a diagram here labeling where each variance is located on the property.
Connor, I love the diagram. Good job on that. Thank you. How did we learn about this case, Connor?
It initially came through with a compliance case for, I believe it was for the carport in the front yard. However, when we go through the pre-application meeting with the property owners, we do have to review the entire property, see if there's other variances that need to be requested.
Okay, thank you. So the property owner came to the city and said, I want approval on my carport, basically. Is that what you're saying?
Right. So the options that they have when there's a compliance case is they can either abate the issue or they can try to seek a variance.
Okay, thank you.
Yep.
Any other questions of Mr. Tomlin?
Commissioner Ebbets, it was brought about through a citizen's complaint.
That's what I was getting at. Thank you, Mr. Duddy. I appreciate that. Because a lot of times we wouldn't hear about these unless somebody complained or you tried to. Wait, hold on just for a second. Board members, any other questions, Mr. Tomlin? All right. Mr. and Mrs. Jones, there are a number of variances you're asking for here. Why should we grant them? Tell us why.
What I found though, there was not a complaint. I went through our public records and I actually had the email and I forwarded that to Connor and I did not get a response to it. There's under the Sunshine Law, everything that I went through in the public records, there was no complaint. It was, if you go back to the date in 2000, I'm sorry.
December.
But it doesn't really matter. I'm sorry. The complaint, who filed it, where it came from.
That's fine. I just was clarifying that if for a department that says that they're a complaint based, there wasn't a complaint. So for him, my husband, they're not about convenience. He lives with sarcoidosis. He is an acute and chronic kidney failure. He cannot be in the direct sunlight. He has uveitis. He has hypercalcemia, which is from the sun. I have all I didn't submit the medical stuff online because I wasn't comfortable doing that. I do have it with me.
We saw a lot of the documentation that you did supply. So thank you for that.
But I mean, I have more that I didn't submit.
I don't think that's necessary right now. Those are private records that we're not privy to see, and we don't want to see them actually. So that was part of it.
Yeah, we can accept your testimony. You're under oath, ma'am. So that's in the public record.
Okay. And then one of the forms just states that he cannot be in direct sunlight, and that's from his rheumatologist.
Okay.
Ma'am, can you pull the microphone a little closer?
Sorry.
Thank you.
The purpose of the sheds and the carport, they keep all of our yard materials. He's a mechanic by trade. It keeps it all safe and not scattered across our yard.
We have a huge problem with homelessness in our area, and I try to keep everything neat and tidy and put away so that it doesn't invite crime on a daily basis. The driveway and the gravel portion in front of the driveway was there prior to us buying the home in 2005. The carport in front of the house was built in 2006. The shed in the side yard was installed in 2005, right after we moved in. It was moved from another property that we once lived in. And the other structures that are in question that do not meet code were built in good faith that they were. So we trusted that the builders took the proper steps to make them compliant, and unfortunately now we found out they did not.
Right.
Can you give us a rundown of what's stored in each of those structures in the rear yard, sir?
In the two carports that are in the very rear, there is a utility trailer, a car trailer, a recreational vehicle, and a old pickup that's a father and son project. I had the carports installed to house those so that I just wouldn't be having a bunch of eyesores parked in the yard. They would actually be under a structure. The other three keep lawnmowers, items for the home, items for doing repairs on my vehicles, things of that nature, and they're all under lock and key.
Are you doing any work on your property where others are paying you for mechanic work?
No.
And who were the builders that built the structures?
They were Mennonite builders that were contracted through a coworker that I used to work with that has since passed. Like I say, the carport has been there for 19 years in the front of the home, and the other building behind the home was built with the same builders. So he had all that contact information. I may note that the structures in the backyard, most of them are 100% steel and are non-flammable. They are anchored to the ground with earth ties so that they do not blow away with high storms. We had a microburst hit our property in 2010. And if you'll notice through the pictures online that the carport in front of the home changed from all white to matching colors to match the house, it was also damaged in that storm. So that was repaired under insurance. All of the structures that are there are color coded with the colors in mind to match the house so that they don't become an eyesore. We have 100% neighbor approval from all the neighbors around us and have submitted letters that have been documented. I know it's a lot to ask for. I really do.
Yeah, and I appreciate that. And you're here and we understand why some of this has happened. It's just this board is we have precedents are set.
No,
and
we
you
understand.
have a lot of buildings on your property.
We do.
Yeah.
And if it, like I say, if it wasn't for the fact of all the issues that we have in our neighborhood, obviously we wouldn't have that many, but we try to keep the place nice and clean and tidy. You can go through all of the photos throughout the years. Nothing really has deviated through of us taking care of the property. We don't live in a really fancy subdivision. We're not even part of a subdivision. We don't have an HOA. We have, the parking in front of the home is a nice feature for us because we live on an extremely narrow 2-lane street with no curbs, no sidewalks. The street directly across from our home drops off, so it's you back off the side of it, you back into somebody's yard because it drops off from the street. The home across from us is vacant. The property across from us is vacant and overgrown, and unfortunately that's where the homeless camp was originally set up 3 different times. Now there's a homeless camp at the end of our street behind Sonic's restaurant, and we put cameras in the carport, and all day long that's just what they migrate up and down the street all day long.
Mr. Jones, the 2 rear carports in the back, they have walls that go all the way down to the ground, right?
Correct.
I have a few photographs that I've seen. And then next to those, it appears to be almost looks like a a unit that would be hauled around on the back of a semi.
It's actually a shipping container.
That's what I thought it was.
Yeah,
Okay,
it's
so
100% steel.
so is that sitting on concrete?
Yes, it's sitting on concrete blocks.
Okay.
The carports in the rear of the home, like I say, they are sitting on concrete blocks. They have feet that run the length of them to the sides that go to the ground. And in the pictures, you'll see that all four corners have earth ties to secure them to the ground to keep them from lifting. And they have a cross cable in the back to further secure from swaying back and forth in the wind to make them more secure. All the sheds are sitting on concrete. The big shed in question is sitting on concrete piers that are in the ground, and then the other ones are just sitting on concrete blocks that are solid blocks. The carport in the front, if you'll notice in the pictures, it is sitting on concrete footings. It is also secured to the concrete footings with tie bolts so that it cannot come loose. And since we had a microburst in 2010, it's held firm. It didn't move at all. To whereas the property owner behind us had a wooden carport attached to the back of their accessory garage, and it took flight and wound up in my property and ruined my fence.
So this is a very unique case, and you might have heard that I've been on this board a long time. I took a little hiatus and I came back, and we have handled so many carport cases. But this case is unique because not only do you have the carport issue, you have all these other side issues which create a real issue. And so, and I understand your situation, but I'm one board member, and I'm really, while I think you're very sympathetic, sympathy can't necessarily rule the day in these kind of cases. And so I do have a question. We used to, in the past, sometimes grant stays of execution for a period of time to allow a party to maintain the property, but not grant a variance with this property, so that when you sell this property, the next person would have to remove some of these things. I don't know if that's something that the board still has the power to do. So,
Remember, we did that in the past, just
yeah,
don't.
I mean, so when we've had someone like this where there's a health issue that is there, but, you know, we don't know how long you're going to be in this property, right? And so the question is can we at least issue a stay of execution for a few years to see how this works, right? And have them come back, without, and maybe give them
Right.
more time to try to reorient the property so they're not having to financially do it all at once, right? But maybe figure out a way to remove some of the things on the property so the violations aren't so large in number. So we try to be understanding, but we also have to understand precedent and do our jobs. And so that's just something, I don't know if this board still has that power to do.
We have not done any of them lately, so word.
Well,
But we did,
nothing's one
we
of-
did, yeah.
Yeah, we did. So I don't know if we need to,
Some of the storage structures bother me,
Yeah.
Mr. and Mrs. Jones. The carport, I kind of understand. I kind of get that, because it's been there forever. I get that. But the shipping container and the storage containers kind of bother me. But I'm in agreement with Miss Otto, who used to chair this position, and a stay of enforcement may not be a bad idea, but I've got to leave it to my fellow board members. And are you planning to move in the near future, distant future?
No,
You said you had children that are 18 and 21 or something like that, or around 18, and your one's going to
18
college.
and 22. This is our home. This is where we plan to stay.
Right.
It's comfortable.
yeah, so that's what I'm saying. I mean, I'm a little bit like Mr. Ebbett. I think I could be convinced that perhaps because of the health condition that the carport makes sense, but all of those numerous storage facilities in the back, I can't think of another case where we had this much, okay? I mean, this is really unique, and I understand why you've done it, folks. I get it. I mean, it's hard, and I understand all of that. I grew up on a farm and we had equipment everywhere. So I appreciate that. First thing I drove was a tractor. People are surprised when I tell them that, Mr. Jones.
No, it doesn't surprise me. I too grew up on a farm.
Yeah, yeah. So I appreciate that, but we live in the city limits and, on farm, we have a lot more opportunities to do things and build things and store things differently. And so we have to follow the law. So I'm trying to think of a way. I understand financially this is a burden for you to start removing these things right away, but if we could give you a period of years to try to figure that out so that you could better afford it, that might be something we could kind of come up with a solution here. I'm trying not to put you guys in bankruptcy court. That's what I really don't want to see.
Yeah, we appreciate that.
So, do we need to move into closed session?
Yeah, I think if
Okay.
you want to discuss
It-
options.
See, I
advisable.
come back to this board and I cause us to do things. I'm really sorry. So folks, bear with us. Yeah, I need to do this again. I move that the board go into closed session to discuss legal matters pursuant to section 610.021 subsection 1 of the Missouri statutes.
I have a motion. Do I have a second?
Second?
Second from Mr. Gorens. Sarah, please call the roll. Sorry.
Corns,
Aye.
McStorf.
Aye.
Sorry,
Otto.
Otto,
Aye.
Wright,
Aye.
Evans.
Aye. We're in closed session. We'll be back in a few minutes. Thank you.
3.5 years and I haven't seen them do their stay of execution.
That'll work.
Yeah, I'll be there.
Okay.
Out in the city, obviously the gravel couldn't. Driveway width is allowed, then we could, I could obviously
Are we, where is it?
I think Alex.
Was it ever off?
Oh, there we go. Oh, there he is.
We good?
Okay.
Okay. We're coming back into session. I need a motion to bring us into open session.
I move that the board return from closed session into open session pursuant to, after receiving legal advice pursuant to section 610.021 sub 1.
Thank you. I have a motion. Do I have a second? Second from Mr. Gorence. Please call the roll, Sarah.
Gorence,
Aye.
Mixdorf.
Aye.
Otto,
Aye.
Wright,
Aye.
Ebbets.
Aye. We're back into open session and there's a couple questions of staff. You want to?
I do. So in terms of the size of this property and the 40% coverage limitation for outbuildings, my understanding is there can be any one outbuilding can be 200 square feet, but there can be multiple outbuildings up to 40% of the property. So what's the calculation? How many square feet can they have in outbuildings?
I would have to have time to do the calculation.
Okay, that's what I thought. Okay, so folks, we need some more information, and I don't think this board is going to be able to do that, and I don't want staff on the fly to make some calculations. So I believe we should continue your case because I need staff to answer some questions for the board by the next hearing. And I think that we need to give everybody plenty of time. So I would move we continue this case for a month or two so that we can get the right information and then come back and then make a decision about this case. But I'm going to give you a little foreshadowing of what you need to be prepared for, at least for this board member. I'm one board member. I don't know how this board's going to vote. I always say this, but you have a lot of buildings back there, right? And understand that I believe you can only have coverage of 40% calculation. So if you have more outbuildings than that, this board is likely not going to let you keep those, okay? So you need to come back with a plan of how you could reduce some of your outbuildings, okay? Number one. Number two, I think the gravel underneath of your, the gravel is a problem, right? I think you might convince this board to let you consider keeping that carport, okay, based on your medical condition. I don't know how everybody's going to vote. I'm just giving you some heads up of how to think about this at the next hearing, okay? But you need to think about how you could work with us so that we can maybe work with you, okay?
If the width of the driveway is approved and I can keep the width of the driveway, I'm more than willing to have, is asphalt an approval?
Yes.
Yep.
Okay,
that's
I'm
fine.
more than willing to have the gravel turned into asphalt.
Yeah, so that's what I'm saying. So I want you, Mr. Jones, to use, and Mrs. Jones, to use your time that we're going to grant you to see if there's some ways that you would be willing to help us
Absolutely.
fix this. But you probably are going to have to consider the loss of some of those out structures, okay? Okay? But we need some more information from staff so we can figure out what the ordinance would allow you to have.
Is that something that we'll have to do in time, or is that something we need to have done prior to?
That we have some more questions of staff and they're going to help us figure that out for you. So again, so I think I'm going to ask staff, do you think you need a month? Do you think you need 2 months to answer the questions that we have?
And I,
Take as much time as you need.
I guess specifically, what question are you looking to have answered? I know the calculation of the rear yard percentage in relation to the existing structures. Are there other specific things that you need from us?
I think our legal counsel is going to have to do some research for us, and that's attorney-client privilege. So that's why I need to.
But from CPD staff, the only question you have is about the amount of coverage.
Yes. And so I'm asking, how much time do you guys need? You know, do we bring these folks back in 30 days? Do we bring it back in 60 days? I want to give the applicants some time to think about this too, because understanding what we're telling you is how are you going to reconfigure and all of that? So do you need 30 days? Do you need 60 days? I'm asking everybody.
So from a staff standpoint, and Jim, you can chime in if you need more time. I could have that in 30 days. If the applicant needs more time, that's perfectly fine. Is 30 days okay with you, or do you need more time?
I agree with you, Connor.
Okay.
From my perspective, 60 days would work better.
Thank you. And what about to the Joneses? Do you need more than 60 days?
No,
Okay.
no.
When's our next meeting in 60 days?
So that would be November 12th.
And
You're out of town, aren't you, Miss
I
Otto?
think I'm starting a 3-week trial. Hold on a second.
December, wouldn't it?
Yeah, if you can put it
Well,
in December, is that a
sure.
problem for everybody?
We don't have a meeting in late December because of our holiday, so December 10th would be
That would work for me because I should be done with that trial. Is that okay?
Yeah.
All right, then I would move that this case be continued until December 10th of 2025.
I have a motion. Do I have a second?
Second.
Second from Ms. Wright.
Corrance,
Aye.
Mixdorf,
Aye.
Otto,
Aye.
Wright,
Aye.
Ebbets.
Aye. We'll see you in December. And like I said, give it some thought on some of those outbuildings. And come on back and feel free to reach out to Connor too.
Yeah, that's what I was gonna say. Connor, make sure you're communicating once you guys do your calculation. Make sure they understand that so they can make a
Yeah, yeah.
educated decision. Okay?
Of course, yeah. Whether it's under or over the 40%, I'll communicate that with them.
Okay, thank you.
Thank you. Thank you,
you, guys.
Mr. Mayor.
Thank you.
Thank you.
Thank you.
Put them at the first, up at the first.
What's that?
You put them up to the 1st of December.
Oh, yeah, they're,
don't have
December
to
10th
wait?
is, December 10th is the next, will be
They
the,
won't have to wait though.
oh,
City staff usually
They'll figure
determines
it
the
out.
work.
that they're figured out. Okay.
Thank you, folks.
Thank you. Number 10, docket.
Docket item number 10 is case CD BZA 2025-117, a request to approve a variance to the location of a detached accessory structure in an R6 zoning district, plus any additional variances on about 38.15 acres, generally located at 2201 Northwest 76th Street. Connor Tomlin is the staff planner for this case. We have the applicant. If you are a member of the public who would like to speak on this case, please raise your hand online or approach the microphone on the podium to be sworn in. We do not have any hands raised online.
Mr. Calvert, I assume?
No, I'm Lance Scott with CFS Engineers.
Okay, great. Please raise your right hand to be sworn. Do you solemnly swear or affirm to tell the truth and nothing but the truth in this meeting today? If so, please say I do or I don't, along with your name and address.
I do. Lance Scott, CFS Engineers, 1421 East 104th Street, Suite 100, Kansas City, Missouri.
Great. Think we have an affidavit for him, Connor? Do we have an
I
affidavit?
don't believe so. Let me double check.
Lance, since you're not the property owner, we need an affidavit.
Yeah, they
You
have
know.
one.
Oh, they do? Okay, that's
Yeah,
good.
I'm double checking.
All right. While he's checking that, which we assume is there are a list of administrative exhibits labeled 1 to 9. We need to admit to hear your case today. Do you have any questions on those exhibits? And if not, do we have your permission to admit them?
I do not, and you have my permission.
Thank you very much, Lance.
I don't have it in the applicant submittal. Check my email.
Connor, we did this, remember last week or a couple weeks ago with Oakwood Country Club. He didn't have an affidavit, but they sent one in. We went back into closed session.
Yeah,
on that one.
I have an email saying it was sent in, but I don't see it in the files.
Well, let's just move on and then
We can make it subject to them providing it within within how many hours or whatever we
Yeah,
used to do that.
Great. What's the section go? We need to make a motion for that.
Let's hear about the case and
Yeah,
then we'll, yeah.
last time we had to approve that we could hear it without having the affidavit on record before you proceeded.
Yeah, I think it was a waive the requirement.
Yeah, no, we've done this before, but we've usually done it. They provide it within 24 hours.
But there was new kind of verbiage that we were
Article
using.
five
Oh, okay.
uses the
Okay.
requirement.
Without having the affidavit beforehand.
I'm learning.
This is E.
Good.
Article 5, subsection E is the section of your rules and regulations that requires the affidavit. If you want to move to
So-
waive those.
I think we do. So we have to have a motion to that, correct?
Correct.
Okay.
I will move for waiver of the board's requirement under Article 5, subsection E of our rules as it relates to a need for an affidavit. We can proceed so that we can proceed to hear this case, but I also will require the applicant to provide that affidavit within 48 hours of today's hearing. That's my motion.
We have a motion from Ms. Otto. Do I have a second?
Second.
Second from Ms. Mixdorf.
Gorens,
Aye.
Mixdorf,
Aye.
Otto,
Aye.
Wright,
Aye.
Ebbets.
Aye. All right, so we're going to go ahead and hear the case. Connor, you're on for telling us all about it.
And you already admitted the exhibits.
Yes.
Yes, he
Okay.
gave us this information. 1 to 9 are admitted.
Okay, so we have docket item 10, CD BZA 2025-117, located at 2201 Northwest 76th Street. This is an R6 zoning district. The request is for variances to the detached accessory garage standards plus any additional variances. This is the general location of the site. A closer look at the site itself, outlined in yellow. This is the site plan. You'll see the existing home on the south side of the property with the proposed detached accessory garage further north. This is a closer look at that detached accessory structure. And these are the provided elevations. It stands at 18 feet in height. This is a map of the lay of the land. Variance request A is a variance of complete deviation to the location of a detached accessory garage to permit that detached accessory garage in the street side yard on the subject site. Again, that's a complete deviation to the location. Substantial change to the character of the neighborhood is anticipated as detached accessory structures and garages are not commonly located in street side yards or front yards of properties. The difficulty could be obviated through a change of design, such as placing the detached accessory garage in the rear yard or interior side yard of the site. Variance request B is, looks like that did not change like I told it to, but the the variance is a variance of 2 feet to the height of the detached accessory structure to exist at 18 feet, which would be a 2-foot variance to the standard. A substantial change to the character of the neighborhood is anticipated as accessory garages in this area where they exist appear to be in general conformance with the height requirements, and the difficulty could be obviated through a change of design, such as altering the design to be 2 feet shorter to meet that 16-foot height requirement for detached accessory garages. That concludes my presentation, and I'm open to any questions.
Thank you, Connor. Any questions to Mr. Tomlin from board members? All right, Lance, why should we grant your request?
All right, thank you. This is a 38-acre parcel, right? And it's fully screened on the east and west sides from any neighbors. And then you can see from the elevation, those are 10-foot contours on those elevations. It's steep between the house and the pond, right? And then if we would move it to the back, it would be closer to the southern residence and it would be more prominent and be difficult. I mean, we can always do it, right? I mean, put walls and everything else, but it'd be quite expensive. Right where we have it located, there's a nice little pad site essentially. There's trees next to it. the owner said he'd be agreeable to, put some evergreens to screen it further from the street. We're over 300 feet from the street, so it's quite a ways back. I think a lot of times the intent is, you have a, you know, third acre site and you're trying to put a shed in front of your house and it's right up on the street, where this is over 300 feet back from the street. And I'm happy to answer any questions.
Why the extra height?
We could get rid of the extra height. If the extra height's a problem, I mean, it's setting back farther, but I talked to him this morning and he's fine with taking that down to 16 feet. I mean, it peaks, it's like 16.4 at the side and it was going up to 18 at the peak, but if we want to reduce that to 16, we're fine with that.
It is a large property, so.
There's a precedent for approving structures in the front yard for these large rural type
Yes.
properties with.
There can be, yeah. Why does he want the 2 feet? I know he said he'd give it up, but I kind of wanted to know why he wanted it.
To be honest, I don't fully know, but I think it was if he had some, like an RV or something, he wanted to get up on top of it to do something, or he had some equipment and he needed to have a lift or something to get on. I mean, bigger's better, right? I mean, I guess it's
Well, not
right.
always.
If you're putting a 3,200 square foot, building out here, that he just wanted the extra heights. But I talked to him this morning. He said he's got no real need for it today. So if that's a problem, we don't have any problem dropping that.
Well, since he doesn't really have a need for it, I'm not sure this board should grant a variance for it if he doesn't have a good stated reason for it, so.
I do have,
Go ahead. No, go ahead.
I do have a question on the general location. Is there a reason the highest point on the lot is selected? Or approximately the highest point on the lot, looking at the contours?
Well, because it drops off in all directions. So that's near the drive, which we have to be, near the drive. There's a tree right there, and like I said, it's a relatively flat spot. Everywhere else is not. So there'd be more earthwork. You'd have more issues with storm drainage, right? You'd have water running to the building instead of when it's at the top of this little hill here. It just drains away from all sides. We don't have to worry about storm drainage issues into the building at all.
Thank you.
And you
Board
said-
members, questions, motions?
And you said the owner would consider more screening?
Yeah, we'd be happy to put some evergreens on that north side.
All right. That's all I have.
Have there been any comments from neighbors?
No.
How far are you from a neighbor?
Yeah. It's quite a way. I mean, this is from any building where, this shows on here, it's 842 feet from the east property line. We're 360 feet from the west property line, and then, almost 930 feet from the south property line, and 328 from the front property line. Plus then there's roads, and then a lot of those buildings are set back on top of that. So we're quite a ways away from any other residential structure.
Cody?
I can make a motion. In case number,
117.
yeah, sorry. In case number 117, I move that the board grant variance request A in the staff report, subject to the condition that the applicant install screening in the form of evergreen type plants or trees, as indicated by the applicant's representative, but deny request B in the staff report, also in accord with the site plan as it relates to request A.
Perfect.
Yes.
Ms. Otto, I would add the affidavit requirement to your
Oh,
motion.
yeah, oh, yes, and sorry, that was a separate, yeah, I thought that, and I would also include that the applicant's agent provide a signed affidavit, notarized affidavit within 48 hours of today's hearing. That is my complete motion.
Good. I have a motion from Ms. Otto. Does someone have a second?
Second.
Second from Ms. Mixdorf.
Gorens,
Aye.
Mixdorf,
Aye.
Otto,
Aye.
Wright,
Aye.
Ebbets.
Aye. Project is approved. Thank you for coming before us today, sir.
Thank you.
Yes, yeah, we're gonna do one more, at least one more.
Well, some of these are multiple cases.
Oh, the next one, yeah.
Yeah, the next three are all related.
So can we do all three then? Will it take that long? And then what do you want to do?
There is zoning violations. No, they're not. 43, 35, 43.
It's driveways.
Bunch of driveways.
Yeah. You know, Teresa, I think it's gonna take longer than what you think.
Okay.
Sorry.
Well, I
Okay,
thought-
let's do lunch and then we'll be back in at 12:35.
Perfect. Okay.
By what clock?
Yeah.
His computer.
Yeah.
That's right.
Interest rates, so.
Or Advil, what do you think?
The lower one, what is that? Everything. I mean, I'm refinancing some personal property.
organization, you need to identify the organization first thing.
I will do that.
Okay.
And then when I give the. Case if someone needs to contact you after about the case, so whatever address that cell phone's that. I don't know. I don't think she.
You're committee yesterday,
I-
committee today.
I'm a busy gal. I do lots of things. Oh, my voice on. I'll be okay.
But I will get it in writing. Yeah.
That's what I do for a living.
Yeah.
For her friend, Crimson Freeze, like to ask, so they had to go through our yard. My husband wrote a very detailed analysis of how you could access while this would work. Oh, wow. They then did not they found a different method to access their own yard.
They wouldn't have to go through your yard.
Very like,
Maybe I should hire your husband.
very detail oriented about those things. If there are any ruts from this, we expect this to be done, this, I was, yes.
Well, I think I need to meet with your daughter and we should talk about being the lawyer.
Good.
Yes.
Good afternoon, everyone. We're back from our brief lunch break and we're going to start our afternoon session. Sarah, please tell us about their companion cases.
Would you like all three of them? Okay. Yes, the next three cases are companion cases. So beginning with docket item number 12, case CD BZA 2025-112, a request to approve a variance to the vehicular use area standards in a residentially zoned district R2.5 to permit the existing driveway to exceed the maximum amount of pavement in the front yard plus any other needed variances on about 0.16 acres generally located at 4335 Spruce Avenue. Docket item number 13 is CDBZA 2025-113, a request to approve a variance to the vehicular use area standards in District R2.5 to permit the existing driveway to exceed the maximum amount of pavement in the front yard plus any other needed variances on about 0.16 acres generally located at 4329 Spruce Avenue. And docket item number 14 is case CDBZA 2025-80, a request to appeal zoning violations related to the maximum percentage of pavement in the front yard of a residentially zoned property on about 0.162 acres, generally located at 4335 Spruce Avenue. Anna Naniski is the staff planner on these three cases. I have Alan Bailey, hand raised online. I will promote you to panelist. If there are any other members of the public who would like to speak on this case, please raise your hand online or approach the microphone on the podium to be sworn in.
I'm the presenter, Gloria Clark. Thank you.
Sorry, I wasn't quite ready.
I have no other hands raised online.
Okay, great. Right with you. Give me a second. Thank you.
Because it was continued to the state. I'm gonna talk about everything.
All right. Can you raise your right hand to be sworn? Do you solemnly swear or affirm to tell the truth and nothing but the truth in this meeting today?
I do.
If so, please say, you said I do. Please state your name for the court reporter.
Gloria Clark Bailey.
Thank you, Gloria.
Address 7704 East 75th Terrace, Kansas City, Missouri.
Thank you very much. There's a list of administrative exhibits associated with your case labeled or titled 1 to 12. Do you have any questions about those exhibits? And if not, do I have your permission to admit them?
Yes, sir.
Those are admitted. Part of that is a presentation to the fine lady to your left. Anna?
Do you want to swear in
Do-
Alan?
do-
Yeah, we have
No, I'm sorry.
Alan Bailey online.
Alan?
Yes.
Oh, thank you. I'm going, you heard me give the oath? Do you say I do?
Yes, I do.
And your name and address too for the court report.
Samuel Allen Bailey, 701 Hollis Avenue, Belton, Missouri, 64012.
Great, thank you. All right, so Anna?
On Ananiski Development Management Division, as previously mentioned, there's 3 cases associated with these properties. CDBZA 2025, 112, 113, and 80. So 80 is the appeal case, and 112 and 113 are the variance cases. Logistically, the appeal case was filed first and then continued to this date to allow for the applicant time to file the variance request. So I'm going to be talking about, kind of all 3 cases in this presentation, but, of course, it's up to the board's discretion for how you want to handle each case. And they're all related to the vehicular use standards, specifically related to the driveway and the maximum percentage of pavement that's in the front yard. So the site is located in the eastern portion of Kansas City. This is a closer look at the 2 sites in question. 2 duplexes, 1 duplex on each lot. They're highlighted in yellow here on the screen along Spruce Avenue near East 44th Street, so within a standard residential neighborhood. So to talk a little bit about the appeal case, what that's about is pavement that exceeds 40% in the front yard. That's a regulation that's identified in 88 for 2012. And the drive, I don't know why there's a question mark on there. I do apologize for that typo. But where the 2 driveways meet the property line there at the sidewalks, that appears to be code compliant. So there's a standard for how wide each driveway should be. There's that little strip of what appears to be like mulch or grass or, that buffer in between, but then each individual driveway width appears to be compliant. That's not what we're talking about here, but the total amount of pavement in the front yard. This was a zoning violation that was launched because of an investigation that was triggered from a 311 complaint. There's some information in the applicant appeal report that you would see that talks about like approved certificate of occupancy, and that's the larger, these driveways have existed for over 2 years, but I'll get into some more information here. This is the site plan for the duplex, like the master plan that was approved for the 2 duplexes. So this is applicable to each site, where the site plan that was submitted for building permit review was code compliant. So we see 2 10 feet wide concrete driveways with the little sidewalk that leads up to the homes. So that was what was submitted through the building permit package and approved by the zoning approval reviewer, excuse me. But then this is what was constructed. So the yellow and the blue highlight the concrete that was identified through the building package, and then in the reverse, the green shows what's grass and the white shows the concrete that was constructed. So not following per the site plans that were submitted when the building plan was reviewed by city staff. To talk a little bit about the certificate of occupancy, there's 2 notes on a certificate of occupancy when it's issued that I'm going to highlight here, where the document that you get when you receive a certificate of occupancy says that, this was reviewed based off of compliance per the plans that were submitted. And attached to that certificate of occupancy case, we don't have any photographed evidence about what was constructed at the time of the C of O is what we refer to it as. So whether or not the driveway was expanded or not after the C of O, like I don't have that information. All this document tells us is that when they went out to inspect the site to issue the certificate of occupancy, this document says that what was built was per plans that were approved. And here's a close-up of some of those things that I highlighted where it says that the project description is this master plan for the duplexes per plans reviewed for code compliance. And the bottom part of the statement, says that we're certifying that the work was done because by referenced permits in accordance with city code. But, if things happen after that, that certificate of occupancy is not verifying that information. So again, some key points here talks about the pavement exceeds 40% in the front yard. The certificate of occupancy is based off of compliance with submitted plans, which did identify code compliant driveways. And alternatives that the property owners have is to reconstruct the driveways to be code compliant, or request a variance, with their hardship argument, which is part 2 of this presentation. And just to remind everyone about the review criteria associated with an appeal, is that it may be sustained only if the BZA finds that the administrative official have erred. And based off of the plan and the permit history that we have and photo evidence, we do not believe that the zoning code compliance staff erred in applying Chapter 88 to the specific sites. So now to talk about the variances, 2 variances for each property, which covers, both duplexes. So I'm going to talk about how the 2 variances are applicable to each property, but when I go into those details, I'm just going to talk about it once since it's identical for each site. So the 2 variances deal with the pavement in the front yard and the parking spaces being in the front yard. So again, site number 1 and site number 2. So the first variance, variance A, is a variance of 458.5 square feet to permit a front yard that is 75% pavement. This is a 48% change from the regulation, and we're saying that a substantial change to the character of the neighborhood is anticipated. A quick glance at some of the neighboring properties on this block appear to have code compliant driveways or other vehicular use areas, and the difficulty could be removed by a change in design. For example, reconstructing the driveways that are code compliant or per the site plans that were submitted when the building plans were reviewed. And variance B is a variance to the features that are allowed to encroach in the required setbacks to permit a parking space in the front yard. So this is a complete deviation. A substantial change to the character of the neighborhood is anticipated, again, because the surrounding homes have driveways that appear to be code compliant. And again, this could be removed by a change in design or parking on the street. So to get into the review criteria for a variance, review criteria A talks about the strict application of the zoning and development code, and if this is causing an unnecessary hardship for the subject property that would not be applicable to other properties in the area or generally in the same zoning district. So as I mentioned before, that both of the sites, when reviewed for the building plan and permit, did come along with a site plan that identified code compliant driveways. So from a staff's perspective, the hardship seems to be a little self-inflicted since they didn't follow the site plan that was submitted with those building plans. And I also looked at Google Street View, and Spruce Avenue appears to be a 2-way street. There's no obvious no parking signs on either side, so there could be adequate street parking as well. Review criteria B talks about the variance and consistency with the zoning and development code. So we take this opportunity to talk about why this regulation exists. So the pavement in the front yard, and that can include driveway width, is used to reduce stormwater runoff issues for properties and prevent excessive vehicular use areas in the front of properties. The location of those parking spaces, so every parking space has to be connected to the street, and it can't be in the front setback. It has to either be pushed back or like within a garage. That is from a traffic safety perspective, that is to ensure that there's adequate ingress egress, to the street. So think of if you have your front drive and it's packed full of cars. If you're backing out onto the street, you may not have adequate sight lines to see a car coming up and down your street. So that is the purpose of that regulation. And then review criteria C talks about substantial justice being done, considering both the benefits that the public is secured by from upholding the zoning and development code versus the hardship imposed on the property owner if the variance is denied. So if the variance is denied, the property would need to be reconstructed so the driveways meet code. And upholding the zoning development code would help maintain the neighborhood consistency when it comes to those particular use areas and help control stormwater runoff. If the variances are approved, then the property owner would be able to maintain the driveways that are existing today, though they don't meet the site plan that was submitted with the building plans. And of course, the city staff is concerned about like the precedent that would set, considering approving large vehicular use areas when what was submitted to us was code compliant. That concludes my staff report. I'll be happy to answer any questions.
Thank you, Anna. Any questions? Okay, so Ms. Bailey, why should we grant your request today?
Thank you so much, everyone, for allowing us to be here and plead our case. I'm going to have my phone because it's notes and I'm nervous.
It's okay.
But because there's some missing information, I'd like to give just a tiny bit of backstory just so you understand like what our motivations were. There's no excuse. We obviously violated the code and we're not going to argue that point. It was just ignorance on our part. And today we're really just would like to explain our reasoning and why we hope today that we will be allowed to have the variance to continue what we're doing in that neighborhood. We have built around 5 properties in Kansas City since we've moved up here. We're an LLC of 2 couples that came together and wanted to build a little real estate empire for our children. So these were the 3rd and 4th building that we've built in Kansas City, and we chose that street because even though the area is kind of iffy, that street in particular is very quiet. The houses are established, the neighbors were nice. But that entire side where you see the duplexes, it was just an abandoned field, trash, overgrown, incredibly steep and difficult to build on, which is probably why they sat for so long. And beside our duplexes is an abandoned home as well. So there was a lot of room for improvement there. And our ultimate goal was we would love to create a beautiful little community right there on that street to add to this street, not to take anything away from. I did talk to the neighborhood association before we built and let them know what our plans were. So that was our motivation going into it. The lots are extremely shallow and they're very steep. We prefer to build garages for the safety of our tenants' vehicles. It just makes people more comfortable, but we're not able to. So we actually created this house plan specifically for this lot and we duplicated it for each one. Yes, the driveway was compliant and of course everything was fine. It was during construction and it was actually myself and the partners having a conversation about, hey, typically there are at least 2 vehicles per unit on each side of our duplexes, sometimes more because this is a 3-bedroom. We purposely wanted a home for a family, no longer what we were building before, which was 1 and 2 bedroom. So with that in mind, we asked the builder, Samuel, who's here today, we said, hey, is there a way? Can we create more space for people to be off the street? Understanding it's a 2-way street. I myself lived there on one side for about 6 months, and I can tell you that if anyone has anyone visiting, that street crowds up immediately. You can see it if you drive by on a daily basis. There will always be cars in the street on one side or the other. So there is a reasonable argument about the congestion on the street. Also, our tenants, very much like the fact that they don't have to park on the street. It makes them more comfortable. It's one reason that they chose our particular duplex to live at. And I know that it would be a hardship for them to no longer have that option, especially since one side does have 3 cars right now. I'm not sure what they would do with that. So I do feel like with that in mind, it would be a disadvantage to that particular neighborhood at the moment to get rid of it. Now I'll actually read what I wrote. With this variant or without the variance, cars would be forced back onto the street, which creates 3 significant issues. The safety risks, on-street congestion makes it hard for vehicles and pedestrians to navigate safely. Neighborhood impact, parking overflow negatively impacts the look of the street and contributes to congestion. And tenant livability. The availability of off-street parking is one of the key reasons tenants chose to live here. And that they said that to me themselves, even though they could not show up today. In addition to the reasons I just listed, the tearing out and repairing of the driveway would create a significant financial and practical burden while offering no clear benefit to the community, especially since the driveway improves safety and reduces street congestion. Samuel did do an estimate and said it'd be around 10 grand. Just telling you personally, for us, that would be extremely hard for us to get done in any sort of reasonable amount of time. The community benefit, this variance benefits not only my tenants, but also the neighborhood by reducing the strain on the limited street parking and preserving the curb appeal. We also own the lot next to it. And so now that we recognize that this is an error, it will never happen again. We already submitted plans to build next to it, to build our 3rd duplex. We will not be extending that driveway. They will just, either way, there's going to be street parking. I would rather not add to it if we don't have to. But I completely understand. I completely understand the case, however. So for these reasons, I respectfully request approval of this variance to allow the driveway to remain as it is. Thank you for your time and consideration. I'm happy to answer any questions. And I call him Alan. Alan will be able to answer questions more related to the actual build.
Okay.
Hello, am I allowed to speak?
Sure you can.
All right, thank you so much. Gloria also had some other stuff typed up, and I just wanted to read her first parts. The driveway as it currently exists exceeds the maximum allowable width under Kansas City zoning code. No new construction is proposed. This request is simply to maintain the existing condition without requiring demolition or reconstruction. The driveway was built in good faith and only later determined to be non-compliant due to width restrictions. Our reasoning is the goal is to avoid unnecessary removal of disturbance of the property in the surrounding areas while addressing the practical needs and residents who live there. The duplex houses 2 separate households, which each often have multiple vehicles, which we've showed in the photos. The extended driveway provides enough off-street parking to accommodate them safely. The only thing I really wanted to add is that there's 4 houses adjacent directly to these sites. And those houses are compliant within code because they have the allotted amount of green space, but they are also the same width of these driveways. So their driveways are 20-foot wide, and the width of this driveway is 19-foot wide for each duplex. It is only 10-foot wide at the sidewalk and at the property line. And we just added the extra parking space to try to keep off-street parking because we thought that was, I just want to say, less bad in this neighborhood to have cars be able to park off street, because if we were parking cars on street, we thought that would cause kind of a hardship to everybody in the neighborhood. So I just wanted to add that it is consistent with the other dwellings in the neighborhood.
All right, thank you for that. Gloria and Sam, did you when you said to the contractor, let's go ahead and build this, did you think of the consequences at the time?
He is the
I can speak to that since, I was the builder and contractor on this job. And at this time, what I should have done in hindsight is I should have requested for a variance then to be able to adjust the site plan and adjust the driveway. We went through all the proper inspections through the city. Just so we're clear, there was no construction done after the certificate of occupancy. We have dated photos of everything because we keep track of our jobs extremely well. And there was no construction done. So it was kind of one of those things where I had thought that if there was an issue, someone would have said something at the time whenever we got our proper inspections done throughout the process of the build.
And that was not the correct way to go about it.
Correct. Gloria is completely right. In hindsight, I wish I would have just reapplied for a variance then, and I would have, gone through the process then, so we're not where we are now.
It's kind of like building a house and you say you're going to build a 2-story house and then suddenly you build a 3-story house. I'm just one board member, but I don't know. I've got to think about it.
Thank you for your thoughts.
Yeah.
So just so that I'm clear, did someone inspect the constructed driveways from the city? That's what I
Yes.
thought. Okay, that's what I understand. So someone
Yes.
came out there from the permitting department, looked at these driveways and issued a certificate of occupancy.
Yes. Yes,
Okay.
ma'am. That is correct on both
Okay.
units.
Alan,
Yes.
you're really loud. Can you?
No, he's fine.
He's fine.
He's fine.
It's
He's fine. It's Zoom. It's all good.
Yeah.
I'm used to being yelled at. It's-
okay.
I'm sorry. I'm on a construction site
No,
right now.
no,
I'm
no.
sorry about that.
Alan, I'm just giving you a little trouble, actually. It's all fine. It's all good. It's all good. I guess that's my problem. I mean, I hear what you're saying. You didn't build it right, but someone at the city should have caught this too. And it could have been fixed then and there. So I'm a little, a little disturbed that that didn't get caught.
But I feel like when someone's reviewing certificate of occupancy, they're not assessing per plan a driveway. That doesn't affect the health, safety, and welfare of the occupant in the building. That is just an access point. So if I'm on site, that's not something I would be looking at as I'm assessing, can somebody use this as a livable space?
Yeah, I hear you. I just,
I think we've had a series of driveways in the past year that have been very excessive in their pavement requirements. And we've had a series of people that we've denied and had them rip out. And I'm just concerned about setting precedent. This is a lot of concrete in one area. I think your initial plan was great. I understand wanting more parking, but that is so much pavement in the front yard. And I think our zoning ordinance is to have green space available, and this does not allow any green space in the front.
In the exhibits that we attached, are there the photos that we took of everything that we exhibited? Are those in there so that we can see what it looks like from the front? I believe that there was 8 photos that I attached.
We did show them.
Yep, we have them. We have them in our staff report. And I think Anna showed a series of them in her presentation as well.
Okay.
I'm just concerned about setting precedent. So as we allow, I know you talked about new developments that you're planning and appropriately sizing driveways moving forward, but as other developers are coming into the city and as they see these wider driveways, I feel like it gives them precedent to then also pursue wider driveways when that's not in our code. But I'm just one board member.
I appreciate that feedback, and we're willing to do anything. But I'm trying to think if there's some alternative other than ripping out the entire driveway and putting it back in and putting our tenants through that. And like I said, can't do it right now anyway. So I'm just wondering, you said green spaces. Is there anything we can do, especially since we own the lot next door, to add more green space, add more trees, add something beautiful to this neighborhood in order to kind of fix our mistake in the best way that we can and then never do it again moving forward? Because our goal is we would like to purchase, there's an abandoned house on the other side, and that's tied to the lot next to it. And we're trying very hard to purchase that. And so we would be the ones finishing that street.
Can I see a up close photograph of the driveways, like how the concrete is sectioned?
And I guess I have a question for city staff while you bring that up. Since this is an appeal, we're determining if city staff erred.
There's the 2 variances
Okay.
requesting the larger one, and there's also the appeal.
Okay.
The order in which you wish
remember.
to
Yes.
analyze those is
3 cases totaled.
Correct.
a variance for each property and
The
the-
appeal.
We did an appeal first and then we were advised like, actually, that's not the best way for you to go. Then we did the variance.
Got it. Okay, yeah, trying to follow these again.
Right, right. I mean, so in essence, the board could deny the appeal, but grant variances, right? Okay, so this looks like you've sectioned this, so that the part that's, in the middle matches the 10-foot width, right? And
Yeah, could
then
you do it
there,
further out?
That is correct.
yes,
That-
that's what I'm trying to understand. Okay.
That
So
is
you have
correct. It
some
is 10.
sections there, right? So what I'm wondering, what if you move, like, there's this, that first curve piece, you could get rid of part of that, right? And still give them something, right? I'm looking to see how you could deconstruct this without.
And add more green where that
Correct.
round part is.
Yeah, no, I hear what my board members are saying about precedent and I agree, but I'm also looking to see if there is some way to fix this and that doesn't create a complete tear out.
Is there a requirement from the city for the number of curb cuts?
No. There could be 2 ribbon driveways for each
Mhm.
unit.
Mm-hmm.
And let me rephrase what he said. From a zoning perspective, there's not a requirement for how many curb cuts. Public Works,
Has standards for
has
driveway
standards.
widths and spacing,
Yeah, correct.
but that's not part of the zoning ordinance, as Anna says.
So literally that whole like sort of half U is what would have to come out on both sides to be compliant. Is that what you're saying?
I think a bit more.
Yeah.
Can you see my cursor?
On that
Mhm.
whole
It's
side.
like, yeah, the whole side on each side would have to be removed.
Yeah, that's what I'm saying. So there's a line in the pavement, right?
Yes.
That matches the 10-foot drive space, right? Because
Yes.
there's 10 foot on either side of the sidewalk, right? Yeah, yeah.
I thought you were talking just the single curve section. You're taking the whole linear piece.
Well, I was that's why I wanted to see how that, I'm
try
gonna call
something
it half
crazy.
of a U, right? Okay,
Mm.
that's how I look at it.
I
There's
see.
a half of a U on either side of what, thank you. Yeah.
There you
Anna.
go.
So I think that's in 3 sections, right? That's been poured in 3 sections, right? So I'm like, what if you take out the first section? How does that make everybody feel, right? I'm just,
Because you'd be able to diamond saw out that.
right, you
that was
could,
better.
right, that's what I'm saying. I'm just
But the-
looking at some way to create some more green space if,
Removing just the first section doesn't make it usable for a vehicle, though.
oh, it doesn't,
Yeah.
right.
And I
Right.
will say they will run over the green space.
Yeah,
to
so
use
that's
that.
the other
Yeah.
thing, right,
Mhm.
so.
Put some shrubs there.
Yeah, and we put rock in between. I don't know if that'd make a difference if we changed that out. We added trees.
Well,
And
rock's
obviously
not gonna make
sod.
it any better.
Yeah.
Right, I mean, I'd rather see concrete there than rock, frankly.
ribbon drives my understanding is that's an acceptable form for like an approach, but is that an acceptable like parking space?
So that could relieve variance A, but it wouldn't relieve variance B, because of where the home is positioned on the lot. And I'm gonna triple check right now, but I do believe a ribbon driveway is acceptable to be the entire driveway. The 2 little strips of concrete that the tires roll on, and everything
Oh.
else is grass.
Mm-hmm.
Yeah, the one thing about that though is if you're parking cars on it, it's gonna kill all the grass under
Yeah,
it,
yeah,
which
yeah.
kind of defeats the
Mhm.
purpose.
I think it goes with the style of the house. But
What does?
the driveway, the way they have it now.
You have any neighbor opposition?
Or
No, the neighbor across the street actually mows our yard. And so he was obviously fine. I did try to reach the neighborhood association again by their number and just, it's his house right up the street, it's like 3 houses down. I didn't get a call back and no one was there. With more time, I could probably go to one of their meetings. I could probably drum up people because we have a really good relationship with the people in the area because we learned from our first build on 18th and Vine in that area. It's important to do that, to build the relations and make sure the neighborhood association is okay. So, No, we have not heard anything. Obviously, someone did complain, but the people that we talked to in that vicinity, I couldn't guess who it was.
Would you find it valuable if we gave you a 1-month continuance to identify how you might want to approach this if you were to reduce this, or would you rather us vote today on what you have proposed?
Like I said, I'm brainstorming with you now. I know Alan's listening, and like cutting out a piece, that we could do that ourselves. We could afford to do that ourselves, but I don't know if that would be enough for the board. So to wait a month, I'm not sure if that would be beneficial.
What if you, go ahead, sorry.
No, I was going to say, I agree with Gloria that, you know, I appreciate everybody brainstorming and trying to come up with ideas. I think the driveways do keep a clean effect, but if it was, you know, if the board decided that, hey, we need to make these ribbon driveways, my couple questions are, if we did that, if I put rock in between there, because the tenants possibly would just kill the grass and it'd be tough to keep grass alive in there. And I think that dirt in there doesn't look good. If we put mulch or rock, does that still account for green space if that was the ruling by the board?
I'm just one board member and I don't think that meets the intent of the code. So
Okay.
in my mind, I think the ribbon driveway is maybe not the right approach in your scenario, and I would rather see more concrete removed, but I am only one board member.
Okay.
There's other duplexes within this area of town. There were some built early 2000s where there's a huge variance on how this concrete is. I know of a couple, and in working this area, they're definitely still going to park on the grass, no matter how much of the concrete you reduce. What I'm thinking is, can we reduce the amount of the variance by taking the concrete that goes up to the property back? That way you still kind of have an additional space, but it's still not as much concrete. And maybe that additional space, if we need to, because I don't know the percentages, take it down even more, have that be the ribbon concrete part, and the space is the half U that you were mentioning. Because I think the green space is needed. It makes it looks nice. I think the concrete all the way up to the house is probably a little excessive. It's having that.
Oh, you're talking about the U on the house side, right
Yeah.
there, like where the porch is.
Yeah, I think it goes all the way up to the house.
It does, yes.
Yeah, I think taking that back, but still leaving you some space for some type of car parking, whether it be a ribbon strip or something. Because you're still going to have too much concrete, but it may be instead of 47%, you're asking for 20.
So it's a smaller variance, so maybe better chance.
Just so that I understand, and just from a structural standpoint, the driveway is being held by rebar that is doweled into the concrete front stoop right there. So I think if I'm understanding you correctly, yeah, as soon as I cut that out, now I present a problem with the driveway underneath having the structural stability to be able to park the cars. Again, I really appreciate the creative thinking around this. The part in the front where the U shape starts, I think removing that, we could probably get really close. I'd have to measure it to find out if we're within the percentage. But again, we know that someone's just going to drive over the grass, and we're trying to keep that as clean as possible. And on a rainy day, they drive through the grass, and then you get mud streaks through the street and stuff like that. So we're just trying to accommodate the tenants with being able to have that off-street parking so that, you know, we don't add to the street parking for safety issues.
What if you structurally on a construction basis, what if you took that half a U, that section, you know, that's on the other side of the 10 feet straight, I'm going to call it the rectangular shape. What if you just cut that straight from the street to the house? Can you cut that with a equipment and still have a?
Yeah, so the price that I was talking about is if I take out that 9-foot section is what we're talking about with the U, and I just leave the 10-foot driveway right there. to be able to come in and cut out that whole section on the right and left side, that whole section there and the other section there. Once I cut those out, then I have to re-excavate around that area and re-sod around that area. I understand if that's what we have to do in this situation, and if that's what the board rules, that's just something that's going to be expensive to be able to do on both of these duplexes. And then I don't know that we will have, people will still try to park there, and then they kind of get their tires off to the side of the concrete because the concrete's not there. I realize that it allows more green space, but it will cause an issue when people try to park there with two cars and then they just park half of a car into the grass, and then we have that problem. This keeps everything nice and clean and tidy with the street, but I understand what you're saying. That is possible. Yes.
Yeah, okay. Yeah, no, I do have a concern about people just parking on the grass.
Yeah.
Yeah.
Yeah. Me too.
So Gloria, I'm not wild about what you did,
Me
but on the other hand, I'm not as opposed to it as I was a few minutes ago, knowing that whoever's the tenant, I thought you were living there, but whoever the tenant is, I know he or she will probably park on the grass. And then that's going to make it worse on the appearance, and we don't allow parking in the front yard.
But I also
So-
think if these are just tenants too, that maybe one tenant might do that, but we're giving a long-term solution to other tenants that would park in the appropriate spots.
Well, I will say that lease is renewed in July, so they will be there for a while, and our tenants tend to stay. We have one tenant who's been with us 4 years, and she actually moved from one to a new one we built. We have good relations with
All right.
What landscaping proposal would you have the board consider for us to say you keep it at these two locations, but you never, ever do it again? So I want to know what you
Meaning-
were talking about there.
Right, because we own the, let's see what picture would help. We own the lot, if you're looking at them to the left, and we're building the exact same design. So we would have a narrow, we're not obviously going to change it at all. Yeah, up the top of that screen is the lot I'm talking about. So Alan, if we were
Yeah.
to- hold on, if
You
we
still
were
may
to
pull up there.
compensate for our mistake on the next build, what could we do to make it green and pretty?
Yeah, I definitely think that we can do the 10-foot driveways exactly like noted in the original plot plan, and we can add that green space there. Sorry, I'm trying to okay. We can definitely add more green space on the next one and just keep within code compliance in the 10-foot driveway and have that one, be the 10-foot space. There will be some street parking that'll have to happen there. But we can 100% make that, landscaped in the front. We could add flower beds. If trees were, something that we wanted to do, we could add trees there that might stop people from parking off of the 10-foot space. So adding trees and bushes would probably create a space that doesn't allow cars to get there. So I don't know that planter beds is the right idea unless we add tall enough foliage to not park a vehicle.
That's my point. I mean, you've got to stop people from parking on the grass, I think. And so I'm one board member again. If the board is inclined to do something like this, there would have to be trees, I think, planted to stop people parking.
Yeah.
Well, I hate all the trees we tear down when we do constructions. I love the idea of planting more.
She would. Yep, she does. That's right. That's right.
I don't know. Okay. Yeah. All right. I mean, I hear what Randy is saying. I don't like it either, but I just don't want mud and tires.
Well, I think there's an opportunity if this concrete comes out, then you can just plant trees at those locations as well. So
Now's a good time.
Did you mean if we tear out the driveway? We can't plant trees, I don't think, that close to the house. It would be, I don't know, Alan, what do you think?
Yeah, we could, if the board rules that we have to tear out those sections of the 9-foot driveway that have that half U. Once we redo all the excavating and everything, it will cost a little bit more money because of course we'll have to get the trees in there after we get the concrete out and stuff. But we could do trees if that's what the board rules. And I would love to be able to keep the parking in these two and then move forward from here so that, like Gloria said, we are the only ones in this neighborhood who are purchasing lots. There's no one else interested in them. The lot that was there had sat there for years, just collecting trash and stuff. And we were willing to try. Gloria is big on trying to beautify a neighborhood and make an area prettier. She's right with the trees and everything. We're doing everything that we think is right for this neighborhood.
Let's
And we're
go.
sorry.
Yes, we are.
No, you sound sincere.
We made a mistake and we are very sorry.
All right, kids, what are we doing?
The appeal case is what number?
80, docket 14.
Thank you.
Appeal.
And so.
If we give them,
so
if we give them the variances, then doesn't the appeal go away?
Well, I think you
call them all separate.
I think you call them all.
Well,
separate.
yes. Oh, yes, definitely. Yes.
Yeah. All right.
We would appreciate you still make a decision on the appeal case.
Yes.
Yes, we will. Thanks, Anna.
I'd offer a motion.
Go ahead.
Go ahead.
Docket number 12, case number 112, I move we deny the variance request.
I have a motion. Do I have a second? Hearing none. That motion dies. Next.
I'll make a motion. On docket 12, case number 112, I move that we grant the variance requested and include a condition that trees be planted such that you prevent further encroachment so that folks will work on dirt, as we've discussed.
On that
And
particular.
future development,
Correct.
Trees or shrubs?
I said trees.
like the trees do.
That's the one that's next to the empty lot. I don't have the addresses connected with the case numbers. That would be 4329 Spruce. right?
No, it's 4335 per spruce.
And you're talking about planting extra trees on the subject site to prevent
However
people
you
from
can do it, right, yeah, however you can do it.
versus
And Gloria, in the
conditioning
new
it to be
house,
on a different property.
you've got the
what I'm
10-foot
questioning.
driveway, and then to the left of that, you're going to
They're
plant
not
some trees.
purchasing it yet, yeah, what I'm sorry.
Yeah, but you can't, we can't make that
No, right.
condition, but I'm asking her as a person
Yeah.
that she promises to do that.
Yes,
Beautification.
easily, I promise.
But
I will show you pictures.
Board member Otto, your condition is to plant extra trees on the subject site.
Right, I
Yeah.
mean, I can put a condition on the property in
Yeah.
question.
Yeah.
Can they
That's
fit a
right.
tree on that
There's
site?
no site, there's no space to fit a tree. It'll just die with that amount of concrete.
Well, Alan, can
there's
you
a
fit
little-
a tree on the side of?
I
40?
can definitely,
Specific here, guys.
I can definitely plant trees on the site. If I don't have to remove any concrete, I can put planter beds with trees next to the concrete and it will not die. The same size trees, 2-inch caliper as what I put in the front of the house that have already grown because they establish the best in the Kansas City area and grow up faster anyways. I could probably put a total of maximum 3 trees to have enough room, but no fewer than 2 to prevent parking not off of the concrete that's there existing.
Okay, I'm gonna go back to my motion now, right? Okay, so in docket number 12, case number 112, I move that the board grant the variances requested and allow the existing driveway to remain and condition that on that property in question, the property owner install at least 2 trees.
Sounds good?
Deadline.
Say it again, Anna.
Deadline, but then
Oh, deadline for trees?
Now's a good time for planting trees, so it would be before November, but yeah, that would be great. That would work on my end.
I will say, I will give them 6 months to plant trees.
Thank you.
And in accord with staff report and site plan.
I have a motion for Miss Otto. Anyone want to second it?
Second.
Second, Mr. Gorence?
Gorence,
Aye.
Mixdorf,
Opposed.
Otto,
Aye.
Wright,
Aye.
Ebbets.
Aye, I agree. So that motion, excuse me, docket number 12,
Yep.
case number 112 has been approved.
Then I have a motion in docket number 13, case number 113. Again, I move that the board grant the requested variance, and again, subject to the planting of 2 trees within 6 months in accordance with staff report and site plan.
I have a motion from Ms. Otto. Do I have a second?
Second.
Second from Mr. Gorens.
Gorens,
Aye.
Mixdorf,
Opposed.
Otto,
Aye.
Wright,
Aye.
Ebbets.
Aye. That has been approved, subject to those conditions.
Yeah, and then on docket number 14, case number 80, I move that the board deny the appeal based on prior cases.
That makes sense. Okay. I have a motion on that one. Do I have a second?
Second.
Second from Mr. Gorens.
Gorens,
Aye.
Mixdorf,
Aye.
Otto,
Aye.
Wright,
Aye.
Ebbets.
Aye. That's been denied.
No more driveways. Okay.
Yeah.
Thank you for the grace. I really appreciate it.
Thank you. Thank you to the board.
Good luck, guys.
We have enough people, if I need to leave now to make a meeting, we're good, right? Another quorums that I am a part of? That acceptable? Okay. Thank you. I'll make it for my 2 o'clock.
Thank you.
Okay.
All right.
You out of here?
We got
Yeah,
you.
we got you.
We got you, Randy.
Thanks.
I'm here today. That's a good thing, right? I don't know. I haven't decided.
Otto.
To give you trouble.
No.
That's why you twins your back.
Yeah, I did. I almost called you guys. and
Michael
said-
he needs to stay too.
What?
Michael and,
Michael
Yeah.
Stain. Yeah, we got Jazz.
Yes?
Yep.
Yeah.
Jazz is in.
Number 15
Perfect.
is case CD SUP 2025-19, a request to approve a special use permit acting as a preliminary plat for a school located in districts R 0.5, R5, and R 1.5 on about 13.31 acres, generally located north of East Meyer Boulevard to the west of Research Medical Hospital. Larissa Chambi is the staff planner for this case. Larissa was not sworn in this morning because she wasn't available, so you do need to swear her in for this. And Roger Offield is online. That's sure.
Dominic Spatafor and Andrew.
hi, Randy.
Andrew Chopin. I don't see Dominic.
Okay.
Okay. Anyone else who would like to speak on this case, please raise your hand online or approach the microphone on the podium to be sworn in.
Podium people.
So we have 2 people online who I believe are both representing the applicant.
Okay.
And I need to
No,
be
I'll swear
sworn.
you in.
Okay.
Can do everybody at the same time.
Okay.
Okay, we good? All right. So, sir, who's online?
Roger Offield, apologies if I mispronounce anyone's name. Roger Offield and Andrew Chopin.
Okay, thank you. Right. So, Roger, Andrew, the 2 people up front, and Larissa, do you solemnly swear or affirm to tell the truth and nothing but the truth in this meeting today? If so, please state your name for Larissa.
Larissa Chambi, I do.
Thank you. And for Roger and Andrew and the 2 guests up front, name and address, please. And I do or I don't.
Roger Ofield, 1815 East 63rd Street, Kansas City, Missouri, 64130.
And there was an I do, Roger?
I do.
Thank you. Andrew?
Andrew Chopin, 1710 Wyandotte, Kansas City, Missouri. I do.
Thank you.
Josh King, I do. 3100 Broadway, Kansas City, Missouri, 64111.
Aye. And?
Allison Gordon, 1615 Baltimore Avenue, Kansas City, Missouri, and I do.
And Josh and Allison, are you for or opposed?
Neutral, if we can take that position.
Yeah, you sure can. Both of
Okay.
you? Both of you are neutral? Great. Thank you. Roger or Andrew, who's speaking on your case today? I need to ask you a few questions.
Roger, do you want to or you want me to? Either
Go ahead,
way.
Andrew. I'll be back up.
All right, I will.
Okay, so did I hear Roger or was that Andrew?
Andrew.
Hey, Andrew, there's a list of administrative exhibits labeled 1 to 10 that I need to admit to hear your case today. Do you have any questions on those exhibits? And do I have your permission to admit them?
You have it. You can
And
put
no
them.
questions?
No questions.
Okay, great. Those are admitted. Part of that is a presentation by our esteemed colleague, Larissa. Please tell us about it.
All right. In front of you today is a special use permit request for 1900 East Meyer Boulevard. This is for the Brookside Charter South Campus. This is the subject location in the southeastern portion of the city. Southwestern, sorry. You can see on this site, let me just actually move this over here. This is the subject location. It is 3 parcels, and the preliminary plat will combine those into one that you see highlighted in yellow. As you can see, the Research Medical Hospital is just to the east, and the property is located along East Meyer Boulevard, which is an established boulevard. And then this orange boundary that you see that cuts through a portion of the property is the recently adopted Prospect Corridor overlay. This is the site plan for the project. The project does include a school with a cafeteria, 18 classrooms, a play area, and associated parking areas, all included in phase 1. Phase 2 includes another addition in this southern wing of the school, and then the football field and track that you see along the southern portion of the school. The school will have space for 360 students ranging in ages from pre-K through 2nd grade, and will have approximately 57 employees. And so this is just a closer look at the site plan and then a look at the circulation through the site. The applicants are proposing accesses off the existing cul-de-sac bulbs to the north of the site off of Euclid Avenue and Brooklyn. And the applicant worked with staff to increase the landscaping along this private access road to the east to provide a sufficient buffer. That access road is not a part of this application, and there is an access point right here that will be used for emergency access and will be gated off. And so just some elevations. I didn't include all of them because there are quite a few wings to the school, but the materials include brick, metal panels, and fiber cement panels as well. And so just going through a couple of the criteria. Criteria A, the school is permitted in the 3 zoning districts that the property is located in, and this proposed use will allow the Brookside Charter School to expand their services to this site and will attract more activity to this area. Criteria C, the proposed site design and the building scale is compatible with the surrounding uses. And criteria E, the applicant has provided sidewalk connections and has also shown those connections for future phases as well. As I mentioned earlier, the property is located within the Prospect Corridor Overlay District, and so there are quite a few variances that are attached, and they were all listed, and they're beginning on page 7 of the staff report. And so I'll go ahead and start with those. Variance request A is a complete deviation to the building frontage standard of the Prospect Corridor Overlay. 100% change. A substantial change will not be produced in the neighborhood's character. The special use permit does show a football field in phase 2. And so while the surrounding buildings are pushed forward along East Meyer Boulevard, which is something that the Prospect Corridor Overlay requires, the existence or the proposal of the football field doesn't allow for the open space to the building frontage to be along East Meyer Boulevard. The difficulty cannot be obviated by a change in design. This would require them to switch their just site design, and that opens up the potential for variances to the Boulevard and Parkway standards. Variance B is a 447.33 foot variance to allow for a 447.33 foot setback from that front property line. It's also a complete deviation. Again, a substantial change to the character of the neighborhood is not anticipated. The property to the east was previously developed with structures that were located more than 100 feet from East Meyer Boulevard. So the proposed location of the building does use those access points to the north and will reduce traffic backup on East Meyer Boulevard. And the difficulty cannot be obviated unless they did a change in design. And again, that would open up the property for variances to the Boulevard and Parkway standards. Variance C is a variance of 37.5 feet to allow for a 47.5 street side yard setback. That's a 375% change. Again, substantial change to the character of the neighborhood is not anticipated. The location of the building is using those access points to the north, and it does have a loop around the building to create a more efficient traffic circulation. And so the difficulty could be avoided by a change in design. However, that would create an additional variance as the Prospect Corridor overlay asks that no accesses to properties be off of streets on the major street plan, which East Meyer Boulevard is. And so if we change the design of that, we would still have a variance to this plan. Variance request D is a variance of 127 feet to allow for 137 foot, not foot, interior side yard setback. That's a 1,270% change. The proposed location of the building, again, with that access lane and the two access points to the north, those are being used to just maximize efficiency during pickup and drop off times. And again, the difficulty could be avoided, but then we would get another variance to the Prospect Corridor overlay. And variance request E is a variance of 90 parking spaces to the Prospect Corridor overlay district parking maximum to permit 110 parking stalls on the subject site. And that's a 450% change. Substantial change to the character of the neighborhood is not anticipated. The surrounding neighborhood does have many industrial uses with large parking lots. And so that the use will match the surrounding area. And as the applicant has planned for the future, that parking lot will be used for after-school activities whenever that football field is in use. The difficulty could be avoided by a change in design. The number of students in classrooms don't require the proposed number of parking. However, they are planning for the future use of that field. There are also two variances to the Zoning and Development Code. They are both bicycle parking variances. And so the first variance F is a variance of 10 long-term bicycle parking spaces to the standard to permit 0 long-term bicycle parking spaces on site. It's a 100% deviation. Substantial change to the character of the neighborhood is not anticipated. This difficulty could be avoided by designating a small area within the proposed building for the storage of those bicycles to encourage employees and any future users to use an alternate mode of transportation. And then variance G is a variance to the short-term bicycle spaces to permit 30 short-term bicycle spaces instead of the required 52. So that's a 57% deviation. There's no substantial change to the character of the neighborhood. It could be avoided by providing more short-term bicycle parking in multiple locations throughout the site. The applicant did work with staff and was willing to provide those 30. Those 22 spaces could be provided. In their statement of hardship, the applicant did mention that there is additional space on the property where those can be placed in the future. And so this variance could be avoided. So just some views from East Meyer Boulevard. This is the access point that's existing. It will be removed when the construction begins. And then just more of a direct view from East Meyer Boulevard. And then a view from Access Road, which is that private road I was discussing. And then here's a view from the Brooklyn Avenue cul-de-sac bulb. There's one condition to revise, which is condition number 6. We are just ensuring that the applicant work with the fire department to ensure that the property is in compliance with all the applicable standards of the international fire codes. And so with that, the City Plan Commission did recommend approval with conditions. And I can answer any questions if you have.
Board members, any questions of Larissa? All right. Andrew, why should we grant your request?
Well, first, thanks for everybody's time here, and we're just super excited to be part of this project. Honestly, why wouldn't you? It's such a great opportunity to have a, early childhood elementary school here built. I think it's like the first one built in like 20 years in Kansas City. If we get it approved, so just be wonderful for the kids, wonderful for the area. Hopefully, we can get the football field pushed through at some point too, and just have more amenities for some of these inner city schools. So I can't think of a reason not to.
All right. And did you notice the conditions that the CPC put for you? Do you have any problem with any of those conditions?
I do not.
And and then we're adding a condition about you working with the fire department that
Revising.
Yeah.
Yeah, we were aware of that one. We've had trouble getting a hold of them, and they weren't present at our CPC hearing. So
Okay.
I've got calls into them, and I'm waiting to hear back. I don't anticipate any surprises there, though. So
Great. All right, board members.
I'm just gonna ask a couple questions about the bicycle variances. So how are these children, how is it proposed that they would arrive to the school? Or is this private?
yes, so this is a charter school, and
That's what I thought. Okay.
they do have a bus system. Roger, do you want to elaborate on how all your kids get to
Yeah, so this building is dedicated for primary at the first phase, so it's pre-K through second. A lot of those kiddos aren't going to be riding bikes to school. They're riding with parents or through our transportation system. We started our own transportation program 3 years ago, so we have our own buses, and they either arrive by parent drop off through our transportation system would be the two main options.
And but the plan is you might build and make this a larger school, right? With grades beyond second grade, correct?
Just third and fourth, yes.
Just third and fourth. Okay, so
Yep.
that's all that is proposed. Okay.
Correct.
That would be in a major amendment, would it not?
Yeah, I mean, go ahead.
The small addition on the site plan and then the football field would be a minor amendment when they're ready for that. If they want to expand beyond that, then we would look at the major amendment criteria.
And at that time, additional bicycle parking could be addressed. That's what
Correct.
I'm asking. I mean,
Yes.
kindergarten through, I can't imagine in that busy neighborhood that you're gonna have a lot of kids little kiddos on bicycles, right? And so I wanted to understand that before I voted on those variances, so that we had some logical reference. Okay. All right, thank you.
Josh and Allison, do you want to come up or come to the podium and say what you wanted to say?
Sure. I have some written testimony. I'm speaking on behalf of an organization, Metropolitan Organization to Counter Sexual Assault,
Okay.
or MOXA. And Allison is the architect at our building at 6500 Euclid. So I've prepared this in writing, and I'm going to keep it to 5 minutes as best I can. So MOXA's mission is to improve the lives of those impacted by sexual abuse and assault and prevent sexual violence in our community. We are the only rape crisis center for the 6-county Kansas City Metro. All of our services are free of charge, and we were founded in 1975. We are currently renovating a property that we own at 6500 Euclid, which will serve as our main headquarters, slated for move-in next summer. As such, we are a direct neighbor of the proposed project site. Firstly, let me say we are already partnering with Brookside Charter in a variety of ways, and we're very excited and generally for their opportunity and expansion, and we support the work and mission. We're excited for a long-term neighborhood partnership. MOXA submitted notarized testimony shown in Exhibit 4, articulating several of our concerns with the traffic posed by the applicant using Euclid Avenue as its main access, with photos for ease of reference. Larissa, I don't know if you want to show those or not, but in brief, and not to restate all of those, but to add and augment. Number one, southbound traffic on Euclid. The traffic study proposed by or given by the applicant calls for a capacity of 45 cars for queuing. but the plan only appears to show 42 car slots, and that 42 cars is the ideal. With gaps and observed queuing currently over 60 cars, the plan appears to be insufficient. Even 3 additional cars spilling that queue into Euclid at the existing cul-de-sac will effectively block Moxa's driveway. Item number 2, northbound traffic. We're likewise concerned about the cars exiting the proposed site back onto Euclid, queuing at the light at 63rd Street and backing up traffic. Condition 8 on page 17 of the staff report, or page 1 of the conditions, added by the CPC, calls for the applicant to investigate altering the phase of the light at Euclid and 63rd Street, but it places no restrictions or solutions if that research or phasing is insufficient. Number 3, I only have 6 total, so I promise I'm getting through this. Number 3, there is a choke point of street parking. As documented in our photos, existing street parking in front of the Social Security Administration on the west side of Euclid, combined with the existing queuing traffic from Brookside at its current facility, it creates a choke point where Moxa's clients, staff, and volunteers cannot pass. Number 4, the timely nature of Moxa's work, and I'll be very brief. 2 points. First, counseling. Clients and families will be arriving for counseling at prescribed times. If they're impeded by Brookside traffic, this could cause a cascading and compounding delay in counseling services for victims and their families. Second, hospital activations. When victims of sexual assault present at hospitals or police stations around the metro, those emergency medical staff and law enforcement contact Moxa's advocates 24/7 to support the victim during a forensic exam or the police report. This activates volunteers and/or staff to respond in person to provide this service free of charge for the survivor. While we can meet a response time of 30 minutes effectively following the existing speed limits and normal driving conditions, the delays of queuing traffic from the proposed site could pose significant barriers for trauma victims in receiving support and crisis intervention. 5, the safety of child pedestrians. The plan has a proposed crosswalk effectively at the edge of Moxa's driveway at 90 degrees. In discussions with the applicant, they have stated they would be open to relocating the student pedestrian crossing to the light at Euclid and 63rd, but this has not been codified or written down, to my understanding. We do not believe a crosswalk for daily use by children is conducive when located directly at the entry and exit point for a crisis response service organization. Finally, the need for the city to impose a solution. Moxa has expressed these concerns to the school superintendent, who's on the call, architects at ACI Bolin, Caw Valley Engineering, who submitted the traffic report during the public hearing at Research Medical Center, and the CPC hearing in August. The applicants have expressed they view their responsibility as limited to the curb of the new driveway proposed where the Euclid cul-de-sac currently is, and tentative solutions have been verbal only. We have also urged the applicant to use Brooklyn as their primary access point to the Meyer Boulevard site. They have said the city would not approve Brooklyn, but we have not seen this material or any study as part of the applicant's documentation. At the CPC hearing, a staff member of the city noted an ongoing comprehensive study of 63rd Street, which may further inform this project. Accordingly, we respectfully ask the BZA to consider its unique role in requiring either a shift to Brooklyn for site traffic or a more robust and binding solution for traffic on Euclid Avenue as part of its approval considerations for this project. 501.
Yes, perfect.
Thank you.
Come on up, Allison.
Very briefly, I think that Josh really covered all of the points that we would like to express today. I just again want to reiterate that we're not opposed to the school by any means. Like Josh mentioned, there's an ongoing partnership between Moxa and the school, but our goal really is to make sure that we're ensuring the safety of not only the students, but also allowing the survivors of these horrific crimes to be seen in a timely manner by Moxa. So I think I would just really reiterate and echo the points that Josh mentioned here, and then just really note that we're not opposed. We just want to restudy this, like he mentioned, looking at Brooklyn or kind of reworking traffic studies to understand that not only was Moxa not accounted for in the traffic study due to the times that it was the traffic was observed on Euclid, Moxa hadn't moved in yet, so there was nothing accounted for. And that's also the same for the very large AT&T building, which could add several hundred cars down Euclid Avenue when we're looking at Brooklyn Avenue that's got no kind of in and out driveways the way that Euclid does. So we really, again, we're not opposed to the school at all. But really, we just want to understand that truly is this the best place to channel all of our traffic, knowing that the traffic studies show kind of 4 to 7 times more traffic on Euclid versus Brooklyn.
Thank you. Questions of the guests?
None of those. I want to go back to the applicant and
Yes.
have Mr. Oldfield and Mr.
Yep.
Chopin address this, because this does sound like a concern that needs to be addressed. And
Well,
I would
okay.
need I would need to hear more about why this hasn't been addressed.
So,
before now.
So
Can I-
it has been addressed. Mox has brought this up a couple of times with us, and at the planning zoning, the planning meeting, it was addressed. Euclid at one time, that area used, AT&T's building used to be a call center and serve about 500 to 600 employees. Right prior to COVID, it switched to basically a data center. So those employees that were at the call center are now working remotely. So it had traffic at that time to accommodate those 500 to 600 employees. The pictures that have been provided or they've shown is currently the problem with queuing on Euclid. All of that parking and the roundabouts and the drives that we have on our new property is going to move all of that, those queuing of cars and that congestion onto our property. We've assured that all of that's going to happen on our property. We're trying to loosen up and ease up the traffic on Euclid. When you use Brooklyn, there's no traffic light there. So it's very dangerous to get out right and left off of Brooklyn. Euclid has a light. It's been in place for the Social Security building, Victoria Arms, and for the school. I've been at Brookside for 16 years, 14 years as a school leader. We've grown our enrollment from 200 students to currently we're at 846 students. So building was never built. That's why we have the problem on Euclid currently. And this is why we're looking to expand and move our primary to a new location.
and if I could chime in as well, we do have a traffic study. The traffic study does show that all of our queuing will be on site. It shows that Euclid is sufficient. Moxo was not accounted for originally in it because they had not moved in. They didn't have traffic. The traffic study is a traffic engineer standing on a corner counting cars, at multiple times. Their peak traffic, based on the information they've emailed us that we passed our traffic study, or our traffic engineer has shown that our peak times don't overlap. So, and we've also accounted for a stop sign so that our traffic leaving onto Euclid is required to stop and allow, for taking turns of, people out of their property and ours. As far as
Andrew, where's that stop sign proposed so I can understand? Can someone
It-
show me that?
is that something you can pull up there,
Give
Larissa?
me 1 second.
There's two bubbles on the north side of the property. One's going to be on Euclid, one's going to be on Brooklyn.
While she's pulling that up, also there is Social Security parking in front of the Social Security building. However, during our peak hours, and our traffic study has shown that there was no problem with parking because they weren't open yet. So during our peak, it's not an issue. And the
And
traffic,
Andrew, when under the traffic study, when was the school's peak? What were those time frames?
AM times are 7:15 is when buses drop off. School starts at 8:15. At the end of the day, peak times are from 7:30 to about 4:05, 4:10.
About how many parent vehicles do you anticipate seeing at peak hours?
It's going to vary. So we just started transportation. Brookside's had the history for not having its own transportation, and all parents were required to drop off and pick up. So obviously that traffic was heavier, but now we are transporting 260 students through our buses. That number is going to continue to grow. So I would say, I couldn't give you an accurate number because the transportation and the buses that we have, we transporting most of our kiddos. The transportation that we have planned, that we have in place, is our buses will not exit north on Euclid. Behind the school, we've been given a permission on the hospital access road for buses and any major deliveries to use that gate on the southeast side of the school so that they can access the hospital access road. When they come down to Meyer, they also must take a right. So we've tried to make sure that our transportation is not on Euclid that often.
And Mr. Oldfield, are you using what size buses in your current
So we currently have two 72 passenger buses, one 30 passenger bus, and then we use shuttles. We have 12 passenger shuttles. Shuttles don't require CDL, so it's a little easier to get drivers. It also reduces the amount of time that students are on a bus route. One of the concerns with transportation is some students are on there for an hour and a half at a time. Our kiddos, if there's only 14 seats, can only be on there for 50 minutes.
So you're saying that since the buses are new, you're not exactly sure how many cars there's going to be.
Correct.
So our traffic engineer has planned for the worst case scenario. I think what Roger is saying is as time goes on, there'll actually be less. But it's in our traffic study for how much he assumed based on how many students there were going to be.
Okay, thank you.
And then were you able to see the stop sign on that?
Sorry, she brought it up. Yeah,
Okay.
yeah, it's there. I see. Yeah. Okay.
And to be clear, what you're saying is that based off of these numbers, the number of cars that you'll anticipate seeing, they should be able to fit onto this property without spilling over onto Euclid, to your understanding?
Correct. And what you're seeing there is the ghosted cars. There is room for a second line of cars adjacent. And Roger has talked about having staff out there to direct traffic to ensure everybody knows to pull forward and, keep it organized.
All right. I know that I had a child at St. Paul School on Main Street, which is a traffic nightmare half the time, but pretty regularly the parents get to know the system. So I'm hopeful that that will happen in your case as well, Roger and Andrew. So Roger, actually. All right. Board members, any other questions or comments? And don't forget about condition number 6.
I'll make a motion. In case number 19, I move that the board approve the special use permit subject to the conditions entered by the CPC and modifying, I believe it was number 6, as presented by city staff in accordance with staff report and site plan.
And the associated variances as well.
Yes, and granting the variance as well.
Great. I have a motion. Do I have a second?
Second.
Thank you, Ms. Wright.
Gorens,
Aye.
Otto,
Aye.
Wright,
Aye.
Hayes,
Aye.
Evans.
Aye. Your project is approved. Thank you, Ms. Chambry.
Thank you.
Thank you. Have a great afternoon.
And Josh and Allison, thanks for coming down for your testimony too. Much appreciated. Thank you.
Docket item number 16 is case CD BZA 2025-105. A request to approve variances to the Boulevard and Parkway standards plus any additional variances on about 3 acres generally located at the northwest corner of the intersection of Prospect Avenue and Dr. Martin Luther King Jr. Boulevard. Justin Smith is the staff planner for this case. And your applicant is Nicola Brainoff.
That is correct. And if there's a Kevin online as well.
I don't see a Kevin. Anyone else who would like to speak on this case, please raise your hand online or approach the microphone on the podium to be sworn in.
Hello.
There are no other hands raised online.
Great. Like to swear you in. So please raise your right hand to be sworn. Do you solemnly swear or affirm to tell the truth and nothing but the truth in this meeting today?
I do.
And state your
Nicola
name.
Brainov. Oh,
Go ahead.
Nicola Brainov, 1815 McGee Street, Suite 200, Kansas City, Missouri, 64108.
Thank you, sir. There's a list of administrative exhibits that we would like to admit for your case today. They are labeled 1 to 9. Do you have any questions on those exhibits, and do I have your permission to admit them?
You do.
Great. Those are admitted. Part of that is a presentation by Justin. Tell us all about it, Mr. Smith.
All right, thank you. Good afternoon, board members. In front of you is docket item number 16. This site is located at 2500 Dr. Martin Luther King Jr. Boulevard. All right, as you can see on the map here, the site is located right along Brush Creek within the 5th District in the boundaries of the Swope Area Plan. Highlighted is the whole site. As you might know, on the northwest corner of Prospect Avenue and Dr. Martin Luther King Jr. Boulevard is the current Emmanuel Center's campus. They have recently, this past year, purchased the rest of the buildings highlighted in yellow and where this plan will take effect. So here's a view looking west along the boulevard here. All the buildings you see besides the one directly on the corner are set to be demolished. So back in May of this year, they did get approval from City Council of the development plan. As seen on my screen, this is a 3-phase development. The development on your screen is all of phase 1. So the additional phases 2 and 3 will get project plan approval. And so I'll go into the variances now. Variance request A is a variance of 10 feet to the Boulevard Vehicular Use Area setback standards. This is to permit a 20-foot setback of the parking lot that I will show a picture of in a moment. It requires a 30-foot setback if it is not behind in the rear of a building. A substantial change to the character of the neighborhood is not anticipated. The parking lot location is somewhat temporary, as phase 3, I'll show in a picture here in a moment, does alleviate the variance request, A and B, in front of you today. And of course, this could be changed. The difficulty could be removed with a change in design, but the site it's pretty shallow, so there's not a lot of places to put parking on the lot. Then variance request B is a variance of 28% to the vehicular use area frontage standards to permit a 38.19% of the site's frontage to be used as a vehicular use area. And so once again, it is somewhat temporary, as phase 3, as shown on the screen here, phase 3 proposes a multifamily housing project, which would then set the surface parking in the rear of that building. That phase 3 on their plan is 3 to 8 years out. So although it is uncertain when it will, the goal is eventually that variance will be alleviated. And then variance request C is a variance of 2 feet to the boulevard fencing standards to permit a 6-foot fence on the side yard of the subject site. A substantial change to the character of the neighborhood is not anticipated, as I do believe the fence is for safety reasons for the daycare. Here's an image of the fence, and then a closer image of the type. I believe it's welded steel to be painted black. And then variance request D is a variance to the Boulevard and Parkway transparency requirements to permit 23% transparency on the ground level facade facing the parkway on the subject site. 33% is required. Staff does not believe a change to the character of the neighborhood is anticipated, as the architecture of the proposed building is somewhat consistent with the existing Emmanuel Family and Childhood Development Center. And it, of course, could be redesigned to provide more transparency, although it might lack cohesion with the existing architecture. Here's just a rendering of the building, and I can also go back if we need to the colored rendering there. And then the final variance is a variance of 2 street trees to the street tree landscaping standard to permit 14 street trees along the frontage of the subject site. A change to the character of the neighborhood is not anticipated, as this is for the construction of a pickup and drop-off area. Although the difficulty could be reduced by adding those street trees along the right-of-way somewhere else. I don't know if their plan would allow them area to put 2 more street trees in the right-of-way or 10 feet setback, which would be the standard. And then here is just a picture of that drop-off area. So there is street trees along the drop-off area. They are just requesting a variance to 2 of those street trees. And that will complete my presentation. I can answer any questions.
Board members, any questions of Justin? Fine. All right, why should we grant your request today?
Hello. I can go through all of these one by one, but I feel Justin addressed them pretty accurately. To start off, this whole development is part of a development plan to create, a first of its kind early education campus here in Kansas City. It ties into the existing Emmanuel Family and Child and Family Development Center on that corner. So this is the first phase, which is a community center, which will have, a multi-purpose space as well as some classrooms and a commercial kitchen, all servicing early education as its primary function. So for the first one, that parking setback, would we be able to pull up? I can share, I suppose.
Sure.
Here you can see a site plan of the proposed parking lot. If we were to shift that north another 10 feet, we would be getting very close to the property line. And the challenge with this site in particular is that at this northern portion of the site, the grade drops pretty drastically down towards Brush Creek. So to feasibly have a parking lot be shifted up 10 more feet would require significant retaining walls. Additionally, as Justin said, there will be, currently we are planning for a future building that would be aligned with that 20-foot setback in the future. So from a practical standpoint, we felt it was very appropriate to only set the parking lot back that 20 feet. And then to go hand in hand with that, the site frontage, we're exceeding the limit on that. And it's primarily due to the fact that that's the only way we can get the required number of parking spots, which is 31. We are showing 32 spots. So to shorten this parking lot frontage up, we would not be meeting our parking requirements for this site. And again, as Justin said, in the future, this particular variance request wouldn't particularly matter. But in the meantime, to alleviate that, we're adding, as part of our landscape drawings, additional trees and shrubbery around the south portion of the parking lot in order to at least provide screening from the public of this parking lot. As for the fencing height, the current standards are 6 feet is allowed in the front and I believe 4 on the rear and sides. We would just like that to be 6 feet tall across the board. As Justin said, this is primarily for safety reasons and security. This is going to be a campus with, children on it. So because there's multiple access points on this site, from the parking lot to the west, to the existing center, to the east, and then the south as well, having a continuous, fencing for security seems to make a lot of sense. Plus, we're going to be tying into the existing fence that surrounds the existing center, which is, I believe, all 6 feet as well. For the facade transparency requirements, the minimum of 33% that is required for Boulevard and Parkway standards is in conflict with the 2021 IUCC glazing requirements, which poses a maximum of 30% of the facade can be glazed throughout a building. In our opinion, the architecture language of this facade aligns very closely with that of the existing center. And within that language, we have maximized the amount of glazing on this facade. Anywhere there's gaps in between windows is where either structural columns or structural bracing is located. So we thought this was a good balance between IUCC requirements and trying to maximize glazing as much as possible. But at the same time, a level of, privacy is expected considering there will be, children in these classrooms. So we don't want to have too much glazing and be too transparent to the public. And then I believe the final one was the tree planting number. That's pretty straightforward. The layout is otherwise compliant. We're just taking out a couple of trees here to make room for a bus drop off, which is very useful for the early education center. I think that covers all of the major points here.
All right. Board members, some more questions of the applicant? Okay. Motions, perhaps?
In case number 105, I move that the applicant be granted the variances requested in accordance with the staff report and site plan.
I have a motion by Ms. Otto. Do I have a second?
Second.
Second by Ms. Wright.
Gorens,
Aye.
Otto,
Aye.
Wright,
Aye.
Hayes,
Aye.
Ebbets.
Aye. The project is approved. Thank you very much.
Thank you all for your time.
Yep. You guys okay? For no break for a little bit? Okay.
Yeah. We only have 3 left. Let's
I know. That's what I saw.
power through them.
I know. Power through them.
Docket item number 17 is case CDBZA 2025-121. A request to approve a variance to the side and front setbacks to permit smaller setbacks, plus any other needed variances in an R 7.5 zoning district on about 0.23 acres, generally located at 8848 Lane Avenue. Stephanie Saldari is the staff planner for this case. The applicant is here. If you are a member of the public who would like to testify in this case, please raise your hand online or approach the microphone on the podium to be sworn in.
Thank you for waiting today. I know it's been a long day. Sorry.
A
you had to
long
wait.
day. It's okay.
Yes, thank you.
Education is always good.
That's good, yeah.
The No one in the virtual audience or?
There were no
Okay,
hands
great.
raised online.
Hi there, guys. Please raise your right hand to be sworn. Do you solemnly swear or affirm to tell the truth and nothing but the truth in this meeting today? If so, please say I do with your name and address. Go ahead.
I do. Oliver Echeverry, 8848 Lane Avenue, Kansas City, Missouri,
Yes.
64138.
Thank you.
I do. Anna Solis, 8848 Lane Avenue, Kansas City, Missouri.
Great. Thank you. Who's speaking on the case today? Good. Thank you. There's a list of administrative exhibits labeled 1 to 9 that need to be admitted for your case today. Do we have your permission to admit those?
Yes.
Great. Thank you. Part of that is a presentation by Miss Stephanie on your case, Stephanie Soleri. Go ahead, Stephanie.
All right, so we have docket item number 17, CD BZA 2025 121. And this is located on 8848 Lane Avenue, zone R-7.5. And the applicant seeks to obtain a variance to permit a porch to encroach on the front setback and another variance for a smaller side setback. The applicant is seeking these variances to resolve an outstanding violation for building a porch and attached garage without permits. Right, so the subject site is located just south of Raytown. And highlighted in yellow is the subject site. And this is the site plan. So this is the porch and the newly built garage. These are some pictures of that porch, the garage, the inside. And then this is an image from, it was 2016. No porch, no garage. And then this is technically taken in 2024. And so we're looking at two variances today. So variance request A is a variance to the features allowed to encroach on the front setback to permit a porch to encroach by 1 foot on the subject site per submitted site plan. This is a 5% increase. So porches can encroach up to 10 feet onto the front setback. The existing porch is encroaching by 11 feet. So that 5% is from that 1 extra foot. A change to the character of the neighborhood is anticipated. So to staff's knowledge, the nearby houses do not have porches encroaching on the front setback. Most of the houses don't seem to have a front porch per what we could see on Parcel Viewer. And the porch can be scaled back by 1 foot to be compliant with the zoning code. Variance request B is a variance of 6.5 feet to the lot and building standards to permit a side setback of 1 foot on the subject site per submitted site plan. So this is an 86% decrease. A change to the character of the neighborhood is anticipated. The attached garage is almost flush with the property line. And to staff's knowledge, the nearby houses have code compliant side setbacks. And can the difficulty be obviated? So the north, let me go back. The north side of the property is occupied by a drainage channel. So nothing can be built on there. The south side of the where the attached garage sits is about 17 feet wide from where the original house wall was. So from here to here, that's about 17 feet. So if the garage were to be reduced in size to meet that side setback, it would be 9.5 feet wide, and it is not enough to fit even one car. But a detached garage could be built in the rear yard to meet the need for a garage. And that concludes my presentation.
Thank you. Any questions of Miss Stephanie? All right. how did this get built and, and why do you need this variance, so to speak?
Alrighty, so I got a bunch of different, reason why we built this for. One is my mom, have two knee replacement, and we need when it's raining, when it's snowing, it's pretty hard for us. It doesn't have no garage on it, To pull my mom out of the car, it's really hard when it's raining. I have to run, and that's why we built it that big because having that space for her, And then the front porch, the same reason. I want her to be outside, to be outside and have, room where she can sit and have fun. This is one of the reasons it's more important for me, that one. And then we got kids, they like to be outside and raining same way. And we have to have that garage in there for. And the other reason is my wife. If I don't build, that thing, it's gonna be a problem for me. So I prefer to have a happy wife and a happy life, So
I like that.
yeah.
She's pretty punching you.
Yeah. So then that's one of the reasons I built that in there for. A bunch of different reasons why.
Right.
Well, and then we get a lot of break-in to our house, not to our house, but to our cars. And the only two houses that don't have garage is ours and our neighbors on front, but all around everybody has garage, not porch, but garage. And one of the main reasons that's why we built that garage, we just got of his equipment stolen in one of our trucks too, with everything of his equipment. So it's just for his mom and then for our safety too.
Go ahead.
As one board member, variance A in regards to the porch, that's a small variance, and I personally, I think it's fine. The setback on the garage is a little more questionable. Have you talked to your neighbors on the corner about that garage?
Yes. No, he was really excited, that I built that in there actually. He got no problem with that. Even we call Evergy because we thought, we're gonna be so close to the they say
There's an easement on that
Yeah.
side.
yeah, and they say no, you build it right. So
So the hardship would be you can't really have a garage when you've got that easement on the other side and you're pushed so close up to that property line without encroaching on that setback.
And you don't have that much space in the backyard even to build another garage. I have a motion.
Go ahead, Ms. Otto.
In case number 121, I move that the applicant be granted the variance request asked in accordance with the staff report and the site plan.
I have a motion for Ms. Otto. Do I have a second?
Second.
Second with Mr. Jazz. Sorry, and Mr. Hayes.
Gorens,
Aye.
Otto,
Aye.
Wright,
Aye.
Hayes,
Aye.
Ebbets.
Aye. Your project is approved. Your variances are
Happy-
given.
Happy wife.
Yes, we don't want you in trouble.
yeah, believe me,
Thank you.
I learned that in the hard way.
Thank you.
Have a
Thank
great
you,
evening.
guys. Thanks for your patience today and watching all of us. And
We learn nothing.
We learn a lot.
yeah, I hope you found some of it funny. I'm just kidding.
Thank you. Thank you so much.
Mr. Rowe, come on up.
Okay, docket item number 18 is case CD SUP 2025-20, a request to approve a special use permit in District R80 to allow for a district logistic hub on about 220 acres generally located at the northwest corner of Northeast 108th Street and Northeast Shoal Creek Parkway. Olafu Agbaji is the staff planner on this case and does need to be sworn in. We have James Ratley online. And James Everard has his hand raised. I will,
James. Okay.
well, a J. David and a James. I'm promoting both of them to panelists. If we
Perfect.
have anyone else who would like to testify in this case, please raise your hand online or approach the microphone on the podium to be sworn in.
Glad to see a familiar face.
Yes, I saw him yesterday. He likes to be called O now.
Oh, okay. All right. I think that sounds like that's something you're saying. Mr.
Like the mayor too.
All right. Got cameras and microphones on for James D or James David and other James. They're there?
Yep, you can hear me?
Yeah, I can now. I'd like to each of the Jameses, along with Olafu, to raise their right hands to be sworn. Do you solemnly swear or affirm to tell the truth and nothing but the truth today? If so, for Olafu, please say, I do, and your name.
I do, Olafu Agbaji.
Thank you. And for the two Jameses, I do, along with your name and address.
I guess I'll go first. James David Ratley. I go by David. Make it this a little simpler if that's okay. Address is 11827 West 112th Street, Suite 200, Overland Park, Kansas 66210.
Great. Thank you, David. And the other James?
James Everard, 6806 West 72nd Terrace, Overland Park, Kansas 66204. I do.
Thank you. And David or James, who's speaking on your case today?
I am. Speaking on behalf of the school district and HDK.
Great. There is a list of administrative exhibits labeled 1 to 9 that we need to admit for your case today. Do you have any questions on those exhibits, and do I have your permission to admit them?
I don't have any questions, and you can admit them.
Great. Those are admitted. Part of that is a presentation by Olafu, better known as O.
Thank you. Good afternoon, Chairman and members of the board, Olafu Agbaji City Planning and Development staff. This next case before the board is a request for a special use permit. And again, this is located up in the Northland, which will be where my arrow is pointing, Staley High School. Again, this is the parcel, about 220 acres, just within the quadrant of 435 north, 435 to the east, and then 169 to the west. The property is actually specifically located, I want to say, at 108th Street, Show Creek Parkway, which is just this intersection, and just west of Maple Woods Parkway. And Staley High School, as you can see, is highlighted in yellow. And this is part of Staley Hills development to the east. Staley Farm Golf Course is to the south of this. And Gurney Park is on the west side of Maple Woods Parkway. Again, this is the area where the school district is proposing to put in what is a bus depot, a transportation hub. The existing hub is at the North Kansas City School District headquarters on 38th Street, or is it 46th Street, sorry, and Davidson. So they want one to the north part. If you look on the side of this picture, just off the existing facility, you see that there are existing buses that do operate out of this site. So what they're trying to do is put in a bus hub for where they can do repairs and also do more buses. You are not going to get 100 buses here at the same time. It's going to be done in phases, but you're going to have those buses that are here and probably up to about 30 total of what's existing plus one. So it's going to come in phases rather than just a big hub, but they should be able to maintain and then house both the drivers and then operate out of the site for the northern part of North Kansas City School District. As you see, the school district, as part of the campus, there are various uses: athletic fields, football fields, track and field, all baseball, softball fields, tennis courts, and all the other uses associated with the school. This is another additional use as a bus depot, but it's going to be at the northern edge of the site. The main concern we had was locating the building up north with potential future single-family development coming just on the north side of this. Our staff was just worried about making sure that the existing vegetation is maintained, which they will. They're not going to disturb anything. As you can see, everything is already clear. They'll stay away from all the existing vegetation and all the natural stream buffers that are around this area. So again, the request before you, special use permit for the bus site. The building is going to be 18,000 square feet. It's gonna be the same red and dark precast concrete to match the campus, make it look like one of the building on campus. Parking will be 216 parking spaces, mostly for buses and employee. They are seeking a variance to the bicycle parking requirement, and I think they were seeking 100%. I don't know if you want to grant 100%, but I don't know if they can provide two long-term one and maybe two in case somebody decides to drive or ride their bicycle to work. So I will probably recommend we just provide two long-term in the building and then two short-term outside. So if anyone, so it would just be a reduction. And if the board wants to grant that variance, it should be two, maybe two inside and then two short-term outside. So if someone does show up. Again, this is the proposed building just on the northwest corner, and then the additional parking for buses. And as you can see, this is the proposed landscaping to kind of increase the buffer and make sure that this is well screened from the future residences to the north. Again, this is the building, would just be straight up red brick to match the campus. They did hold a public neighborhood engagement, and this went to City Plan Commission on August 20th. Recommendation was for approval subject to conditions. That ends my presentation, and I'll take any questions.
Any questions for Olafu? Yes, go ahead.
Mr. O, I have, how are they gonna go in and out? Can you go back to that picture and see how are they gonna go by the football field and all the sports and out by the school?
It will take the same route. So they will use the same route coming through, and then eventually the same route. And that's just the buses, and they usually have a different time. They come in at 6, and then they come in after kids are gone from the school. So, and again, they do exist right now, and they're right here. So I think they will straighten this out, so you can just go ahead and move most of this to the north.
The bike parking you were talking about, that specifically pertains to this bus depot and not the
just to the bus depot. Originally, staff is okay with not having any, but just if someone does not live too far on bikes to go pick up, to go drive, or they don't drive, or if they're just visiting or working there, say one of the mechanics wants to bike to work, and they do have that option.
What does the ordinance require that they have? What number would they be required to have just for that new facility? You said 2 and 2. I was just curious what kind of variance that would be.
David?
I apologize. I don't know the number off the top of my head, but I know it's pretty significantly more than that. And for a facility that wouldn't generally require demand, I guess that amount of spaces. So
it is a lot.
Okay, I was curious what it is, right?
I was mainly concerned. I've biked to school when I was younger, so I do think it's important to have but if it just pertains to this,
it'll be school district staff, employees that's utilizing this space, and bus drivers. There would be no students up in that in that facility.
Makes sense.
I can't read it. It's in this.
It's okay. And I guess since Olafu had suggested this, is the applicant okay with having 2 long-term and 2 short-term spaces for this facility? Is that something you would agree to?
I think from an exterior standpoint, I don't see necessarily there'd be an issue other than where to put it based off, because the type of facility it is, where you have a dedicated bike rack for that on the exterior. We can look at to see what that looks like, but I guess I'm reacting to, haven't had a chance to react to that yet to what that would look like. But from an interior standpoint, I'd let James mention if he has any room in the inside of the building for anything like that or not.
I would say within the building, there is no room. The operation of the building is a lobby, a large meeting room for district professional development, and then offices and the operations center for the logistics of the bus travel, and then the maintenance and wash bay. The floor plan's pretty tight as it is. And I think currently, if anybody brought a bike, it would most likely be on a bike rack outside. The district uses every square inch of their buildings. So I think if they were required to do a bike rack, it would be on the outside. And if they had to do something, we'd probably look at putting bike storage in one of the alcoves by the maintenance bay, but I don't think they would welcome anything on the inside, just with how the current plan configuration is. Not saying it's not, I think we can definitely work with something on the outside.
I'm not seeing these a variance in this particular staff report.
There was none because it was just going to be a full 100%, and staff is not comfortable given the. So they have the original, my original condition was they were asking for what would have been an administrative adjustment, which I can do via an administrative alternative compliance to the bike. So we will go that route, and then I'll work with them to find something that works. So
if they need a variance, they'll have to come back to us for that.
I'm going to do an administrative adjustment.
Okay.
And then have them work with me to make sure we have the actual bike rack. So it will be a separate application.
Okay, so we only are concerned about the special use permit at the moment.
So we won't touch the bike variance today. So are you guys okay with not dealing with the variance today?
Yeah, if we can move the project forward, I think that's the key here is that I think the district would be willing to work with you on something like, as James mentioned, that'd be on an exterior basis. I think we could find a space to have a number of bike slots that could be dedicated for that. It's just we'd have to work it out with the city staff and the district as to where that goes, and then the number. Is this based off of what the facility is being used for, and circulation of buses and just everything else? We want to make sure that it makes sense, that it goes in the right spot. It's not going to be obstructive to that use, since that's what we've been planning from the beginning of the project. But I think whatever that process looks like to make this to where we can move forward, I think that's what everybody would probably be in favor of.
Yep, that would be a separate application. It would be an administrative. It would be an administrative application, which I will send to David. So.
Yep, and I'll work with you offline on that one, Olafu.
All right, thank you.
I do have one quick question for the applicant. Would this replace the bus depot by Northgate, or is it like to supplement it?
Yeah, what's going on is the pre-existing transportation facility that's being used by the district now is quite a ways away from this current location in this community that's served on the north end. And the intent is to help spread that out, or be able to kind of help cover the areas better, to where bus drivers and maintenance and all that isn't so far apart from where the high school is. So by providing this facility, they're going to be able to maintain service to the surrounding area, and as this area grows, they're going to be able to provide that service to the community area better than what they would if it's going from providing that service from the south pre-existing one now. So at some point, as Olafu mentioned, we're going to start with 30 as phase one, and they're going to build up to about 90, I think, is what our layout shows now. So for the ultimate master plan, for at some point there'll be up to 90 buses that will be supporting this area as it grows and demands it.
And David and James, I appreciate, you've got to tell us why we should grant the variance. I know we're kind of getting in the weeds of things, but tell us why.
To add to David's comment and the original question, this is to expand the district's administrative services. So right now, everybody is at the south side of Davidson, and they have to go all the way up north to Staley. So doing the transportation hub up here to supplement that will help spread resources more efficiently around the district. The Northland is growing, so the district sees this as a strategic location to expand those services. And that's why they would be looking to have this facility approved.
All right.
I'll make a motion.
Go ahead.
On Docket item 18, case CD SUP 2025-20. I move that we grant the special use permit in accordance with site plan and staff report
And the conditions therein.
and the conditions therein.
Thank you very much, Jazz. I have a motion by Mr. Hayes. Do I have a second?
Second.
Second by Ms. Wright.
Gorens,
Aye.
Otto,
Aye.
Wright,
Aye.
Hayes,
Aye.
Ebbets.
Aye.
Nice to
Thank
see
you, O.
Olafu.
Good to see you.
Last one.
Thank
Thank
you.
you, everyone.
Appreciate it. Have a good day.
Thank you.
Docket item number 19.
Ah,
Who was that?
That was them saying Yahoo.
thanks, everybody.
You're welcome. Okay, humor is good. Okay, that's all right, humor is good. That's hysterical.
Docket item number 19. Case CD BZA 2025-102. A request to approve a variance to the Boulevard and Parkway standards related to setback requirements, plus any other needed variances on about 28.9 acres, generally located at 11029 North Euclid Avenue.
Gentlemen, do you have anyone in the virtual audience?
We have no hands raised online, but if there was anyone out there who would like to speak on this case, please raise your hand online or approach the microphone on the podium to be sworn in.
I got it on my flash
We
drive
still
already.
have no
You wanna
hands
do that?
raised.
Okay, great. Thank you,
Yeah.
Sarah.
Okay, do you want me to use the PowerPoint? Okay.
Hey, guys, you ready?
Sorry.
Thanks. It's all good. Thank you for your patience today. You're the last case of the day. Please raise your right hand to be sworn. Do you solemnly swear or affirm to tell the truth and nothing but the truth in this meeting today? If so, please state I do, along with your names and addresses. Go ahead.
I do. Jacob Hodson at 1301 Burlington Street, North Kansas City.
Great.
I do. Aaron Schmidt, Hummel West, 1881 Main Street.
Great. Thank you very much, gentlemen. There's a list of administrative exhibits associated with your case. They are labeled 1 to 9. Do I have your permission to admit those, or do you have any questions on those exhibits?
I do not. Please admit them. Thank you.
Okay, great. They are admitted. Part of that is a presentation by Miss Anna to your left.
Okay, thank you. As previously mentioned, this is case CD BZA 2025-102, and the applicant is seeking approval of a variance to the Boulevard and Parkway standards to permit a smaller building setback for a 177 unit cottage house project. So the property is located in the northern portion of Kansas City, Missouri, First Council District, actually just near the case we were just discussing, near Staley High School and Maple Parkway and Shoal Creek near Ann Gurney Park. So you can see a close-up of the site highlighted in yellow right here on the screen. And then this is a picture to show that there is the property is applicable to Boulevard and Parkway standards from both of the sides of the property. And this is the standard from the Boulevard and Parkway section that we have in question, where it says 1 and 2 unit residential structures fronting onto the parkway shall be set back a minimum of 30 feet. So the smallest it can be is that 30-foot setback. And this is a little screenshot from the applicant's site proposal, where you can see Shoal Creek, and then the building setback line, and then there's 2 rows of those cottages that are a part of the complex, and then followed by the parking. And I wanted to highlight this so you can see how close it is to that 30-foot separation, as well as the 10-foot separation between the 2 rows of cottages, which is another requirement of the zoning and development code. So it's not just as easy as pushing the structures back. So this is the zoning analysis for the variance. This is a variance of 5 feet to the residential parkway standards, the setback minimum, to permit a 25 foot setback instead of the 30. This is a 5-foot change, a 5-foot variance, 17% change from the requirement. This will cause a minimal change in the character of the surrounding area. The surrounding developments do have that 30-foot setback, and a change in design could obviate the need for the variance. So this is the review criteria associated with the variances. The first one, strict application of the zoning development code that results in an unnecessary hardship for the property that is not applicable to other properties that are zoned or in a similar situation compared to those regulations. So due to the shape of the lot, the proposed site layout, including all of the proposed parking ratio for this particular unit, complex unit. So a couple of the buildings do encroach into that 30-foot setback. So from a city staff's perspective, yes, the variance request is minimal. It is a little self-imposed, because of the design and the amount of parking that they want on the site. A change in design could obviate the need for the variance, but that could result in a loss of the proposed number of buildings or parking spaces. And from a site plan perspective, the development plan that was processed, there is value in having this type of housing mix in this area. So we do propose the amount of density that is being proposed for the site. Review criteria B, and I point over there because Olufu processed the case. No longer sitting there though, so my apologies. Review criteria B it talks about the relevance of the variance in terms of the intent of the zoning and development code. So we take this opportunity to talk about why this regulation exists. So the boulevard and parkway standards exist in generally to promote high quality development along existing boulevards and parkways, but also when we're establishing new boulevards and parkways, making sure that high quality design is there ahead of time. And more specifically, the setback standards is to create that scenic development pattern that we associate with parkways. And review criteria C, which is, will substantial justice be done for the public in terms of upholding the zoning and development code versus the hardship imposed on the property owner if the variance is denied. So if the variance is denied, then the development plan needs to be amended so that the buildings are outside of that 30-foot setback. If the variance is approved, then the building plans and permits could be pursued if the city council approves the rezoning and development plan that's associated with this variance request, which was reviewed by the council committee yesterday. No? Yes? Okay.
It was held for 1 week.
Okay. They reviewed it, but then held it. That concludes my staff presentation. I'll be happy to answer any questions.
Any questions of Ms. Anna? Go ahead.
How many units total?
177?
Oh, is that with houses and apartment or combination of them?
They're cottage style homes, so they're detached dwelling units, but all for rent.
Okay.
Mhm.
With parking?
With parking in the surface parking in the middle of the complex. Mhm.
All right, Aaron or Jacob, what do you want to talk about?
Well, I'll be presenting, and I sent Anna a quick presentation to highlight some of these issues.
That jump drive will be exhibit number 10 and admitted. Thank you.
All right, thank you. Well, thank you, Chairman and members of the board, for the opportunity to present our case today. Now, before you is a little unique request because we're also asking for some wider setbacks in order to move forward. How do I move? Oh, scroll.
Oh, okay.
It's not being shared.
Oh, okay, let me fix that. Thank you, Sarah. Okay, try the pack, yep.
This project, as Anna said, is located in the first district in the northeast corner of Maple Woods Parkway and Northeast Shoal Creek Parkway, right between Ann Garney Park and Staley High School. Because this property sits at the intersection of two parkways, section 88.810.512 of the code defines it as a development node. The proposed maintenance provided master plan single-family development sits on approximately 28 acres with 177 detached homes. Hunt Midwest and the design team worked a lot with staff in both the planning department and parks to develop a site plan that maintains a unit density that is needed to make this a fiscally viable project while maintaining the open space that goes with the suburban character of the area. The front doors of the houses along Maple Woods and Shoal Creek do face the parkway. Where constraints allowed, there's pedestrian access that connects the residential units to the existing trails along those parkways. The additional setback from the parkway where we are required will not only relieve from some hardships, it will also provide additional landscape buffer between the parkways in this development. I am requesting a variance from section 88.32303-A as well of the Boulevard and Parkway standards from, I quote, 1 and 2 unit residential structures located on a boulevard or within a development node shall front the boulevard. Front yet setback shall not exceed that required by table 110-2. Table 110-2, the proposed buildings can also not be any further away from the property line than 25 feet. This creates a hardship on Maple Woods Parkway due to the 20-foot utility easement that spans more than 27 feet past the right-of-way line onto the property in some locations. An attempt to follow the section of code would either place the buildings within that utility easement or require retaining walls over the top of existing utilities. The section on the right-hand side of this slide shows the relationship between the parkway, the utilities, and the proposed clubhouse. The proposed clubhouse has been placed as close to the parkway as possible while maintaining landscape buffer at a reasonable slope and without requiring retaining walls to balance the earthwork. While working with park staff, we decided that a request to an area of variance would be more applicable than a standard distance. The right-hand side of this slide depicts those areas in a red hatch. We are asking for a variance area of 6,100 square feet north of the entrance of the drive on Maple Woods and 5,500 square feet south of that drive. Because the amount of additional setback required varies between 12 and 835.5 feet along the parkway, city staff has asked for a variance request at a total area to allow flexibility in that final design. Shoal Creek Parkway poses some of the similar hardships. The existing steep grades would require retaining walls on much along the frontage to get the buildings within that 25 setback. During meetings with city staff, the fire department review was very clear that a retaining wall would impede emergency access to those residential units off of the parkway. Because that retaining wall was a non-starter, the buildings along Shoal Creek were moved back out of the right-of-way just far enough to get the grading in without retaining walls and maintaining a visual consistent line of the front facades. This equates to a variance that varies in distance between 5 and 18.5 feet, or a total square foot of 9,300 square feet of additional setback area. Your approval to the variance of section 88.32303-A of the Boulevard and Parkway standards today would also allow for a much-needed residential development in the Northland to move forward. I thank you and welcome any questions you may have.
Thank you, Jacob. Any comments, Aaron?
I've got about an hour-long presentation. But I'll hold
Sorry,
it
you're
for a
out.
later day. Just a little bit more color. Really, it's just the utility easements. We can't build buildings or retaining walls in utility easements, and definitely can't do the retaining walls to prevent fire access. So that's really the hardship.
And neighborhoods yesterday liked the proposal. Is that what I heard? Yeah, when you were neighborhoods council yesterday? I think you were there yesterday.
Yeah.
All right. Questions, Mr. Gorens?
These houses will be for sale, right? No leases, no.
No,
rents?
they'll be all rental units.
All rent.
Detached, single-family homes that will be for rent, maintained by a professional maintenance company.
And where's parking for the cottages?
So there's surface parking behind it with internal to the site. There's also garages, detached garages in there. And then a few of the larger units have attached garages to those buildings, and then they have driveways.
Got it.
Footage, average.
That is a good question. Do you remember that off the top of your head, Aaron?
Have to go back and look. Some of the 3 and 4 bedroom homes are pushing 2,000 square feet though.
A lot of rentals, isn't it?
Well, might be a good place to retire if you don't want to have a lot of maintenance,
Mm-hmm.
as I'm aging myself.
What's the average rental? You gonna keep them up there?
So the rent ranges are from 2,000 to 3,000 plus per month. So it'll be a high end, top quality type project.
Obviously, I live in that district.
Yep. Any question, board members, or motions?
I have a motion.
Go ahead.
In case number 102, I move that the board grant the special use permit. No, I'm sorry, the special
Variant. These are variants.
sorry, these are variances, sorry. I move that the board grant the variances requested in the staff report and site plan.
Perfect. Thank you, Ms. Otto. Do I have a second?
And
Second, Ms. Wright. Oh, wait.
and hold on. You want 2 variances?
Yeah. So
Okay.
because this is a special case, because it is a development node, we're actually in violation of 2 different aspects of the Parks and Boulevard standards. So
Were they listed in the, were they?
listed in the staff
were-
report?
I only thought 1 variance was
Oh,
necessary.
okay. So then I need to amend my motion.
Yes.
Okay, so my motion, do you want to, do we have a?
it
good
would be that
listing?
section 88-323-03-A.
So it's the same piece of code. It's just you're requesting the same setback variance for the 2
No,
different
they're different.
parkways.
No, they're different.
They're different because we're in a development node based on the definition, because we are at 2 intersecting parkways.
Let's do this. So, the staff report cites one clearly. I'd ask the applicant to clearly state the variance that's not in the staff report for me, please.
So we're seeking a variance to 88-323-03-A of the Boulevard and Parkway standards that states 1 and 2 residential unit structures located on a boulevard or within a development node shall front onto the boulevard and have a front yard setback that shall not exceed the required by Table 110-2.
So I'm going to move to amend my motion to include the second variance request just articulated by the applicant. And that would amend my motion.
Great. Ms. Wright?
Second.
Still second? Okay. Please call the roll, Sarah.
Gorens,
Aye.
Otto,
Aye.
Wright,
Aye.
Hayes,
Aye.
Ebbets.
Aye. Your project is approved. Good luck with it.
Thank you.
And
Thank
we
you.
5 minutes away from our hard stop at 3 o'clock. So
Right.
we made it before the end. All right. Thank you, everyone. Thanks, board members, for your patience today. Thank you. I know you had to point out the Diet Coke.